Good morning, Your Lordship. May I proceed with the call out?
Yes, of course. Yeah.
Thank you. CFI 070-2022 and is being held by way of video conference before Justice Lord Angus Glennie, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by KBH Limited. Lead counsel is Ms. Bushra Ahmed. The defendant is represented by Davidson & Co. Lead counsel is Mr. Andrew Trotter. Thank you, Lordship.
Thank you very much. Mr. Trotter, it's your application.
Thank you, my lord. Can I firstly just check that your lordship has received everything?
Yes, including a supplementary bundle this morning, which I haven't had a chance to read.
Thank you, my lord. And
I think I've read the things in it, though, in some different form. Most of them.
Yes, my lord may have received those separately. And I'm sorry, we've tried to avoid the evil that occurred on previous occasions, with my lord having to re-download the bundle several times. But in the process, we may have created a different monster. So I'm not sure which will turn out to be the lesser evil.
Let's see. How do you want to do this? We've got. I think I told you through the court registry that we have maximum 4 hours.
Yes,
and out of that, we'll need at least a 10-minute break at some stage.
Yes, understood. Well, we'll keep a close eye on the time. My lord, before we begin, there's just one matter of housekeeping. The parties have agreed in relation to the confidential bundle that there should be an order preventing public access to it, at least without permission of the court, sought on notice to the parties. Subject, of course, to your lordship. I think we're quite close to agreeing a form of wording for that order, and if that pleases your lordship, then we needn't trouble you with the detail now.
Provided there is the ability for members of the public to apply to the court, then then I'm content with that. But that should be made clear on the face of the document.
Yes.
Rather than hidden away in a subclause.
Yes. No, it will be. Thank you, my lord. And in the course of this hearing, we'll just refer to it without reading out the confidential information. No one's urging your lordship to go into closed session or anything like that.
Yeah.
So my lord, this is our application for a document production order and other related orders concerning the manner in which the claimant has gone about his document production exercise. What I'm not going to do is traverse all of the background. All I'll say is that, of course, we don't accept the way it's put in my learned friend's skeleton argument, but it's not going to assist your lordship for me to waste time going over that now.
Yeah.
What I propose to do is to address you on the different forms of relief we seek by moving from the specific to the general. So I'll start with the individual categories of production that we ask your lordship to order. And my lord, in relation to those, there's been something of a flurry of activity from the claimant in the last few days. So we've had some amount of late disclosure, some promises to provide more. And I'm pleased to say that has gone some way towards narrowing the issues, but it hasn't fully resolved them. And the positions, it's slightly different in relation to each request. So I'll just deal with that as I go. Second, having dealt with them, I'll deal with the specific information that we ask your lordship to require Mr. Kahlon to include in his revised document production statement when it comes, so that we can understand what's gone on. And just to be clear, the issue here is not just about updating in light of the missing disclosure or correcting the various inaccuracies in it. It's about the type of information, because the approach that's been taken leaves us very much unable to understand the nature of the search that's being conducted. And on that front, we haven't received any concessions. So we do ask your lordship to impose some discipline on the next DPS that we get. And then third, I may need to deal with an issue of principle that's developed between us about the method of document production. And in particular, the question concerns whether the DIFC courts should follow the long-standing common law approach that requires solicitors rather than their clients to decide whether documents are responsive or not. And we say the same rigour applies in this court. My learned friend says it doesn't. And we can deal with that when we get there. Now, your lordship may have picked up that there's been some narrowing on this issue as well. There was, in the evidence, a concession in relation to the Yahoo account, which the claimant said he would hand over to his solicitors. Yesterday, in correspondence, we're told that Mr. Kahlon is now willing to hand over the personal hard drive to his solicitors as well. Now, obviously we have concerns about why it's taken so long to do that, but that's not for today. The two difficulties which are holding up the resolution of that issue are, first, that the offers are conditional upon certain things, and second, that the promise that's been made is confined to those two existing repositories. So there's no promise to conduct the disclosure exercise in that way going forward in respect of the various other requests we're making or the various other repositories that we've identified. So there's still that issue of principle that remains between us.
Yeah.
So we'll see how far that distance is when we get there. So, my Lord, turning then to the individual categories, the best place to start, I think, will be the draft order. It's in the hearing bundle. Yeah, at page 12.
I haven't printed it out. Yeah.
Thank you, my Lord. That will be useful. And so the particular categories that we seek are listed under paragraph 2, 2.1 down to 2.10. And I'll take them broadly in order, although there are some that we can group together for convenience. So the first group of categories are 2.1 and 2.3, and they both concern ArcelorMittal. My Lord, in fairness, I should note that some documents have been provided in relation to this on Monday. Those are the documents that Your Lordship has in the confidential bundle. And now they were collected based on the claimant's narrow reformulation of the issue. And consistently with that, our concern is that they really don't illuminate the narrative at all. And they really only confirm that the search that we asked for is required. So I'll address those in a moment. But first, if I could just show Your Lordship how this arises on the pleadings.
Well, can you just tell me on the pleadings rather than take time turning up every reference?
Yes, my Lord, that's perfectly sensible. So the stock options, my Lord, at ArcelorMittal are said to have been an important part of the remuneration package that the claimant had. He says that they would have vested over the period to 2030 and that they would have been very valuable. And he says that he would not have left ArcelorMittal but for the promise of receiving the LTIP when he came to Liberty. And so a key part of the case is, well, we must have agreed the LTIP as I say we did, because otherwise I never would have given up this very valuable bird in the hand that I had when I was at ArcelorMittal. And that's said not only as a matter of fact, of the matter of the background, but it's also said in the reply to support some kind of estoppel on the basis that he relied on, well, something is not very clear, but by giving up that suffered a detriment, and so therefore we're stopped from denying the validity of the agreement.
Yep.
That's the broad shape of it. Now, my learned friend, well, the claimant also made a disclosure request on this issue. Can I show my Lord that? It's at page 766 of the bundle.
Hang on. Sorry, let's see. 766.
Yes.
Yep.
And so in other words, says in the far left-hand column, the claimant's request, this is a request relating to the discussions about the prospective remuneration package. And then in sub 1, there's exchanges with Mr. Gupta, and in the middle they're specifically concerning, and at the end of sub 1, the value of the ArcelorMittal stock options.
Yeah.
And the reason for that comes in the next column across under 2, whether there are documents relevant to the issue that the agreed upon terms was significant enough to induce the claimant to leave his high-ranking role at ArcelorMittal, including the compensation from the ArcelorMittal stock options.
Yes.
Now, we made a request to explore this issue as well, because obviously the position in relation to ArcelorMittal and the stock options, his resignation and the like, are all uniquely within the claimant's knowledge. We have nothing to test this claim that he was giving up this very valuable bird in the hand that would have vested over that period. And really, that question encompasses three issues. First, what are the nature of these stock options? Second, were they going to vest? So was he going to receive the value of them?
Mm-hmm.
And third, relatedly, what were the circumstances around his leaving? Were there other reasons why he was leaving ArcelorMittal?
Yeah.
Now, we've seen some disclosure late last Friday regarding the stock options. This is not confidential disclosure. This is in the hearing bundle at page 1363.
Do I need to set it up?
It might be useful, my lord. It won't take very long.
And I'm just concerned that if we get bogged down in every reference, we will not finish.
Yes,
And then,
I'll take that
then
on
we'll
board.
get their order.
Yes, I'll take that on board, my lord.
Yeah. What 1363?
1363.
Yeah. What am I looking at?
Now, this is a spreadsheet that's been disclosed that was exchanged between the claimant and his recruiter while they were working out his existing remuneration. One sees, you see row 13 and row 15 refer to stocks.
Yeah.
And then if one traces across, one sees that the total is listed in the highlighted yellow column.
Yeah.
And if one looks up to the top of that yellow column, we see what the stocks were dependent upon.
Yeah.
And so the question arises, well, was the claimant going to meet these targets? Was he going to be retained? Were there any other conditions that were going to be met? Or is the true position that he was quite happy to jump ship in the hope that some LTIP might be agreed in due course at Liberty, because that was better than anything that he was going to get at ArcelorMittal?
Yeah.
Now, the documents that are going to illuminate that issue are not the formal or contractual documents, although of course those are helpful as well. What we really need is the narrative documents, the contemporaneous emails and messages about ArcelorMittal that illuminate what was really going on in Mr. Kahlon's mind when he decided to leave. Now, we made requests for those, and those are the requests that my lord saw in the order a moment ago, and they broadly concern, first, the nature and value of the ArcelorMittal stock options, and second, the reasons for his resignation.
Yeah.
Now, what we got in response was some very narrow formulations, and the difference between the formulations is helpfully set out in a table in Mr. Swangard's witness statement, which is in the confidential bundle.
Which witness statement of Swangard is that?
I'm sorry, it's the third statement of Mr. Swangard. It's in the confidential bundle, which my lord has received separately.
I have it separately. Okay.
I see. So on internal page 3 of that statement, one sees there a table with, on the left-hand side, our original request. In the middle, the counter proposal, and on the right, what we've applied for. And what we've applied for is very, very similar to what we originally asked for. But in the middle, we can see in bold the limiting words that have been built in to the counter proposal that's come from the claimant. And so one sees, first of all, in relation to the stock options, they have to be specifically related to the governance regulation. They have to specifically evidence or demonstrate his belief in the value.
Yeah.
Well, my lord, the problem with that is that excludes communications that are going to show whether the stock options were going to vest, whether targets were going to be met, and so on.
Yeah.
And put around the other way, we're not really sure what the resistance is to documents related to the ArcelorMittal stock options in general. What are they trying to exclude here? And then if one comes to the resignation request, in a sense, the position's even worse, because to qualify for production for documents, they need to satisfy 3 conditions. First, they have to directly reference discussions with Liberty Steel and the terms specifically mentioned in the first 5th of September letter, and specifically relate to the remuneration negotiated with the defendants.
Yeah.
And so again, we don't really see the principled objection to disclosure of documents related to his resignation generally. And in a sense, this is just the continuation of what we saw on the last occasion, where the requests or counter requests from the claimant are being drafted in a very nebulous way, when really the issue is very simple, and one ought to be just going and finding all the documents that have anything to do with the stock options or anything to do with his resignation. Now, for the first time in response to the application, we have received some documents. It said that these were always going to be produced once the confidentiality order was agreed, although my lord will remember that was posed on the last occasion. Now, but the point here is that when Mr. Kahlon says he's going to produce these documents, he's taking them off the shelf in response to his own earlier narrow formulations. And so the difficulty is that when one looks at the documents, it really just confirmed our concerns that one doesn't see the narrative around the stock options and his resignation that one wants. And so if one looks in Mr. Swangard's statement at paragraph 10, one sees in relation to the stock options, we have various formal documents, some formulaic emails attaching them, and then over the page, documents concerning the extent of the vested entitlement and an email. Now, the problem is that some of the documents, as we see at the very bottom, have nothing to do with the stock options at all. And if I can just give Your Lordship a sense of the more formalistic documents that we're talking about, one turns to, for example, does my lord have the confidential bundle?
I expect so, if you give me a second. Yep. Yep, I have it.
So, for example, if we just turn to page 7,
yeah,
we're in the confidential bundle, so I won't read this out, but my lord can get a sense of what sort of document it is.
It's headed ArcelorMittal, is it?
Yes, that's right.
Yeah.
And there's 4 different versions of a very similar document to this through the bundle. And that's the sort of thing that we have. Now, I mentioned before that we'd like to see the narrative to see whether and to what extent Mr. Kahlon really thought that the conditions were going to be satisfied. Can I just show my lord something in relation to that? Page 19.
Of the same bundle?
Yes.
Yeah.
Again, I won't read this out, but my lord says the last bold italicized heading.
Performance realization.
Is my lord on page 17 of the bundle?
No, you said 19.
Oh, I'm so sorry. It's 19 of the PDF, but 17 of the paginated bundle.
Right. Okay. And with orange and red bold.
That's right.
Background. Yeah.
That's right, my lord. And if my lord just sees the text just immediately above the table.
Yeah.
And then if we see the table and the nature of what's set out in that table. And then having seen that, if my lord turns to page 72 of the PDF file, which is paginated page 70.
Yeah.
Now, there's a table on this one again. On the far left-hand side, we have some dates.
Yeah.
And then if my lord sees the third column across,
Yeah.
those figures.
Yeah.
And then in the far right-hand column, my lord sees how those figures evolve over time.
Yes.
Now, we don't have anything like a full picture of these. Part of the problem is that we only have certain sorts of files for certain years. But the problem is we don't, that is exactly the reason why we need to see the narrative around this.
Yeah.
So that's what I want to say about the stock options. Now, as regards the circumstances of his resignation, the position is even worse. We've got two documents that have been disclosed. Can I show my lord? The first of those is at PDF page 83.
Of what?
Of the
Same
confidential bundle.
Right. Yeah. 81 of the internal numbering.
That's right.
Yeah.
And so my lord can see what the nature of that document is. Again, it's a formalistic document that's not helpful in showing the reasons. And then the second document is at page 79 of the PDF.
Internal 77, is that right?
Internal 77.
Yeah.
Now, just to orient you, the claimant's pleaded case is that the first 5th of September letter was signed in September 2019. He resigns in October 2019, and he started with Liberty, he says, from the 1st of January 2020.
Yeah.
So he's leaving ArcelorMittal to join Liberty. He's not retiring to the seaside to play with his grandkids. Now, if my lord sees the date on this email, and can I just invite my lord to read the first 4 lines of the top email there, in particular the words in parentheses.
Right, hang on, give me a sec. Yeah.
And then, I mean, one doesn't need to read the entirety of this email chain, but it's really more of the same. For instance, if one scrolls 2 pages down, page 81.
Yep.
So it's internal page 79.
Which part of that?
And so there's an email that starts midway through the page.
After begin forwarding message.
Yes, that's right. And just below that, if one just goes down 2, 4, 6, 8, 9 lines.
I've lost.
Yes, if my lord just reads that through to the end of that paragraph.
Yeah.
So, my lord, this shows part of the story, but my lord will understand why I say it doesn't really throw very much light on the narrative. And we don't understand why there's a reluctance to disclose information and documents regarding the circumstances of his resignation generally.
Right.
And I should add, we don't accept, of course, that the hard drive that these documents were retrieved from is the only place worth searching. My lord will have picked up there's various other email addresses, phones, and so on that ought to be searched. And so for the moment, all we're seeking is that the search be carried out by reference to the broader issues as we have framed them and not confined in the way that the claimant has counter-proposed.
Yeah. Okay.
That's all I propose to say on that issue.
Should I hear Ms. Ahmed on topic by topic?
I think that's probably a sensible way to proceed, subject to your lordship.
Ms. Ahmed, are you happy with that?
Yes, I am, your lordship.
What's the problem with these two categories, 2.1
Well, Your
and
Lordship,
2.2?
I beg your pardon, Your Lordship, we don't accept that Mr. Kahlon is trying to exclude any documents in the way that's been suggested by my learned friend. Nobody is trying to exclude anything. There is no principal objection. The point is that the requirement under the rules is that there is a proper search conducted, and we say that that proper search has been conducted, and it's as a result of the proper search that these documents have been produced. I mean, if the documents don't exist, then they don't exist. What Mr. Trotter is trying to do is broaden this search, or the categories rather, and is going on a complete fishing expedition, which is out with the rules, Your Lordship.
Hold on a second. I thought you disputed the terms of the search in 2.1 and 2.3. Mr. Trotter showed me your version, which was narrowing wording in it.
Well, Your Lordship, things have moved on since then quite considerably. I mean, you'll recall that there is sort of some background here. In the first instance, and to put this very shortly, when the defendants produced, or rather served their request to produce, I think it was on the 27th of September, the claimant filed his objections on the 7th of October, and that can be seen at page 792. And within that, in accordance with the rules, the claimant objected or reformulated the requests, and then produced documents on the 15th of November in accordance with your order. Now, one of the issues with regards to these categories of documents, and it's 2.1, 2.3, was that they were subject to provisions or arrangements in respect of confidentiality. And so once those had been agreed, those documents responsive to the request and those documents that the claimant had in his possession, custody and control were then produced. Now, in terms of the chronology, perhaps if I can just help you.
Just so I'm clear on this, are you saying you don't now object to the terms of 2.1 and 2.2, 2.1 and 2.3? It's simply the question of whether you've already complied with it.
Well, yes, and just to add to that, we've never objected, Your Lordship. As soon as, I mean, there's been a whole flurry of activity in terms of when these requests were first made. They were first made on the 20th of December. You'll then recall matters got overtaken by dealing with the claimant's application. The claimant never objected to providing those, but before the claimant could do anything about it, on the 7th of January, the defendants then issued their application, we say prematurely. Once we'd had an opportunity to engage with these requests, we have, and of course it was subject to the confidentiality ring order being agreed. Once that was agreed, and that was I think on Monday of this week, the claimant then proceeded to disclose documents, conducted a search, in accordance with that search, produced documents that you have seen, and we say that there is no further documents that the claimant can produce because there is no other documents that exist. And what?
Hang on a second. I just so I'm clear on this. If you go to Swangard 3, it's page internal page 3 of that affidavit. Yeah. He sets out the defendant's request, your counter proposal, and the defendant's application. Are you on the same page as me?
I beg your pardon. I've got Swangard 3. I'm on internal page.
It's internal page 3.
Yes.
With your counter proposal.
Well, Your Lordship, that was back in October.
Well, it is. Just bear with me. Is it insisted on or not?
I beg your pardon, Your Lordship.
Do you insist on the revised wording, or are you content with the wording now claimed in 2.1 and 2.3? Leave aside whether you've given the documents yet. Just on in terms of wording, are you happy with the wording in 2.1 and 2.3?
Well, Your Lordship,
Yes or no? It's quite simple.
Well, Your Lordship, I think it is simple, but I think it needs to be put into the context of what's happened here. When that wording was first proposed, I'm not interested
in a dispute about how we got to where we are. That can be dealt with in costs. But I just want to know: is there any objection in principle to categories as defined in 2.1 and 2.3 of the draft order?
Your Lordship, there is no objection in principle, and furthermore, the claimant has conducted a search against those documents and has produced all documents in his possession, custody and control responsive to those categories of documents. And as I understand my learned friend's argument as developed, is that there ought to be more, and it's quite, and speculates that there ought to be more, but there is nothing more, Your Lordship, and that's a completely different argument to what's now being said, or what we understood the argument to be.
Right. Okay. So I interrupted you anyway. So you don't object in principle. You say you've given everything there is.
Yes, Your Lordship, and the claimant.
Carry on.
And the claimant is prepared to verify that in a document production statement, and has said as much as early as 31st of December.
On the face of it, it seems slightly surprising if there's only a handful of documents relating to the circumstances of his resignation, for example.
My Lordship, be that as it may, I mean, and this is what I was trying to explain in terms of the formulation of those requests. I mean, first of all, we say that they're not in accordance with the RDC. That's the first point. The second point is, in any event, just to short circuit this, the claimant has conducted reasonable searches, has found the documents that are responsive and that are in his possession, custody and control, and has provided those. Now, the other point that has been made in correspondence is that these documents were on a Yahoo account. There was a cyber attack on the Yahoo account, and I just need to get the dates right for that, at some point in February, I think it was 2019, and therefore documents in that email account were destroyed because of the cyber attack. And again, that's something that he has set out in a witness statement, verified by a statement of truth. And so, Your Lordship, the claimant's position is that these are all the documents he has. I mean, if he doesn't have any further documents, then he can't produce them out of thin air, Your Lordship. Your Lordship, you're on mute.
Sorry. You can hear me now?
Yes.
Yes. Just to be clear, this is a search. Well, we'll come to this issue later, I think, but this is a search he has carried out himself without intervention from the solicitors. Is that right?
Your Lordship, that's correct. And there is obviously a bone of contention between the parties as to what extent.
I'm not asking for the argument now. I just want to be clear.
Yes, but further to that, Your Lordship, in his witness statement in response to this application served on the 15th of January, he has said that he will allow his solicitors the opportunity to search as long as it's within the parameters, search the Yahoo account, as long as it's a proportionate search. And that proportionality is with reference to any keywords that the defendants can provide to allow the...
What keywords would you expect with category 2.3? And you can't have keywords, can you, in that?
Well, Your Lordship, as long as it doesn't anticipate or envisage, as long as the defendants don't envisage the claimant's solicitors eyeballing each and every document that the claimant may have. I mean, as it's understood in the way that the defendants have presented the position, that is what they are expecting the defendants, the claimant solicitors to do. Okay. And so in that context, Your Lordship, it would be helpful for the claimant solicitors to understand what precisely is it that they're looking for and any key terms that they could search against to ensure that to ensure proportionality of any searches that they conduct.
I'm finding difficulty in understanding what the problem is with 2.3 seems the clearest possible wording.
Well, Your Lordship,
I can't understand what keywords would advance that search.
Well, I think Your Lordship, the claimant has produced, he says, has conducted a proper search, and that's the requirement under the RDC, to conduct a proper search of the documents he has. There's no explicit duty on any solicitors to conduct the search themselves. Be that as it may, the claimant has offered up to his solicitors the opportunity to search the repositories. And I think there's one repository, which is the Yahoo account, which has been in contention, and the hard drive on which the claimant says he stores all these documents. He has offered up to the defendants that his solicitors will conduct searches on, and not just 2.3, on all of the categories of documents within paragraph 2.
Okay.
I mean, if it's just, Your Lordship, if the question is just in relation to 2.3, one can quite see that category is quite narrow, and that the claimant solicitors would be able to conduct a search against those date ranges of September 2019 to November 2019, against search terms relating to the claimant's resignation. But again, the point is, Your Lordship, that the claimant has given a witness statement to say that he has conducted a search. He's produced all the documents that are relevant to that category.
All right. Mr. Trotter, do you want to come back on this at all?
Well, my lord, his position is that he's produced the documents in response to his own formulation. And we haven't seen the documents that one would expect to see from messaging accounts and email accounts, including not just the Yahoo account, but the others that we've identified and so on. But in a sense, my lord, all today we're asking is to formulate the issue. I would hope that there's not going to be disputes about the nature of the search again, but if there are, that's not for today. We just need a ruling about the nature of the issue that they need to search for.
It seems to me that in principle 2.1 and 2.3 should be searched for, and we'll come on to the question of how it's done separately, I think, in your second or third chapter.
Thank you, my lord. Now, the next one. Yes. Sorry, we've got some low-hanging fruit ahead of us now, I hope, so we should be able to knock out a couple of them fairly quickly. 2.2 in the order.
Yeah.
All communications.
Marwar?
Yes. So Mr. Marwar is the recruiter through whom the claimant was hired. So there were discussions between him and Mr. Marwar relating to the process of negotiating the terms, and so that's why those are requested. I mean, for our part, we're quite surprised that they weren't captured by the existing issue about the discussions of the terms, but that issue was formulated with words such as strictly relate and so on in them as well in Mr. Kahlon's counter-proposal, and it may be for that reason they were excluded. But the short point is that this one has been agreed, and unlike the ArcelorMittal point, this one has been agreed in the formulation that we have requested. And so, and Mr. Kahlon has produced some communications since our application was issued. Now, the communications that he's produced, we don't accept that they are complete. And so we would like his solicitors to search them again, but we'll come on to that in relation to the point of principle later. Yep. For present purposes, because the issue is agreed, I say that there should be an order recording that, so that if there's an issue about his disclosure being incomplete at trial, it's clear beyond doubt that he had an obligation to produce documents responsive to that issue. And my lord, just in anticipation of what my learned friend might say, this is different to the situation we had on my learned friend's application, because my learned friend's position is not that this is unnecessary because it's already covered by some other issue. The position is that this formulation that we have requested is agreed and has been met since the application was issued. And so to make sure that there is a source of an obligation to produce documents responsive to this request, we would ask your lordship to make the order formally.
Yeah. Ms. Ahmed.
Your lordship, again, the point is simply this, that the claimant has conducted a reasonable search and has produced all documents relevant to this category. Now, the point that my learned friend is saying that he doesn't accept they are complete, but he's saying that quite blindly without actually saying why he doesn't accept they're complete. He hasn't pointed to any document in any of the production to say, well, this relates to a different document and the claimant hasn't produced this. Or he hasn't said, for instance, that there isn't a document in existence and we know of its existence and the claimant hasn't produced it. None of those submissions have been made, Your Lordship, and therefore the submission is rather scant as to why a document production order ought to be made. I mean, the question is whether or not there's been a reasonable search. And of course, we'll come on to the point of principle as to whether or not the solicitors should have actively searched the repositories. And that's a different point. But in circumstances where the claimant has said he's conducted a reasonable search, he's provided all responsive documents, he's provided a witness statement with a statement of truth verifying that. I mean, on what basis is my learned friend suggesting to the court to go behind that? And so, Your Lordship, we don't accept that a document production order ought to be made, especially in circumstances where my learned friend is simply speculating that he doesn't think that they are complete. In any event, Your Lordship, Mr. Marwar, the recruitment agent, was recruited by Mr. Sanjeev Gupta of the defendants, was in constant communication with Mr. Sanjeev Gupta, and therefore, Your Lordship, being the defendant's man, if there are any documents that they think do exist, then the defendant can quite easily request those documents from the defendants themselves.
You say that Ms. Trotter hasn't given any reasons for thinking that other documents must exist. In paragraph 54 of his skeleton argument, gives examples of why he says there must be other documents. You may say you've looked and there aren't any, but it's a fairly succinct explanation of why there must be, or there are likely to be, further documents. And 54.1, 54.3.
Again, paragraph 54.1, Mr. Marwar sent Kahlon's details to the defendants nearly a year earlier, May 2018. Your Lordship, in that context, May 2018 was before February 2019, when Mr. Kahlon said that there was a cyber attack on his email and therefore he doesn't have any documents prior to February 2019. And the defendants actually refer to that at paragraph 54.2. Yeah. Notwithstanding that, again, 54.1 is grounded in pure speculation that because they were talking to each other, Marwar and Kahlon were talking to each other, therefore there must be contemporaneous documents. But again, that is pure speculation. Mr. Trotter doesn't point to any piece of evidence that gives rise to that. It's purely inferential. And 54. I beg your pardon, my lordship.
Evidence often gives rise to inferences, and that's the nature of evidence. I mean, you say it's purely inferential. It's inferential based on the evidence they've got so far.
I appreciate that, your lordship. But again, if one looks back to the regime in the RDC, it has to be targeted. It has to be proportionate. This is simply just, we say, a fishing expedition. It's far too broad. In any event, your lordship, I come back to the point. A proper search has been conducted, which is reasonable, which is proportionate. Any documents that the claimant have been produced, and therefore, your lordship, there are no further documents. And Mr. Kahlon says that in his witness statement, and that's verified by a statement of truth.
Okay.
I mean, I appreciate there's an entirely separate point about the solicitors conducting the search. But again, your lordship, and that has been put forward as an offer for the claimant solicitors to do that. But again, it goes back to my initial point and my principal point, which is there simply are no further documents that exist.
Okay. Right, Mr. Trotter, do you want to, I wonder if we're going to get this, sorry, I don't mean this disrespectfully, but if we're going to get the same response, that it all turns really on the point about solicitors carrying out the search rather than the client himself, should one deal with that first, and then some of the low-hanging fruit might fall? Or
your lordship,
but my lord, the low-hanging fruit are sort of low-hanging fruit of different kinds. So I'm a bit reluctant to get diverted into that question at this stage.
Can I just interject? I beg your pardon, just to respond to that. I think quite rightly, as you point out, I mean, it is going to be the same submission in relation to all of these categories of documents, insofar as the claimant has conducted a proper and reasonable search. He has produced all documents that he has in his custody, possession and control. And therefore, the overarching point is whether or not that, or rather the search should be, or the further search should be conducted by the claimant's solicitors. And I say this, that maybe that is the point to be grappled with at this stage, notwithstanding that that debate might be entirely academic, because the claimant solicitors have offered to conduct searches of the Yahoo account and, as I understand, the hard drive. And so, Your Lordship, potentially we could short circuit all of this.
My Lord, I don't agree with that. It's not going to be the efficient way to carry out the rest of this application. My Lord, can I first respond to the...
It's your application, so I think we'll have to, subject to seeing how it goes, I'll go along with the way you want to present your case.
Thank you, my Lord. I mean, just 3 short points in relation to this. First, I understand that it's said that these are all of the documents. My Lord's noted in our skeleton argument the reason why we have doubts about that. And so, in a sense, regardless of whether my Lord thinks that the searches should be carried out by solicitors or by the claimant personally, we wish to have the order. And so it's clear that there was an obligation to find these documents, so that at trial, if there's an issue about whether they're complete or not, that can be explored under cross-examination. Now, second, as to whether this is a fishing expedition, we just don't understand that, because the formulation has been agreed by the claimant himself. And then the third, on the question of whether this is somehow speculative, I don't want to take my Lord through the documents, but perhaps I'll just show my Lord one in the application bundle at page 1388.
Yeah.
So one sees there at the start of the email, below is the exact details of the claimant's package as given by him in his own language for your understanding. And then some details are set out below. Now, inferential or otherwise, it clearly suggests that there was some communication between Mr. Marwar and the claimant before this email was sent. Now, there are various communications like this. Those communications may or may not have happened by the Yahoo account that's said to have been the subject of hacking. But for present purposes, my Lord doesn't need to resolve that, because all we want is an order on the formulation that the claimant has agreed, so that we can be sure that either he or his solicitors, as your Lordship will determine in due course, is obliged to search for and produce the relevant documents.
Yeah, okay. I follow.
Thank you.
Yep.
But my Lord, that's all I wish to say on this issue, and I'd urge your Lordship to make the order in the terms that we've sought.
Ms. Ahmed, the point made is that regardless of whether your client says he has conducted, and regardless of the question of who should conduct the search, it needs to be placed formally on record that there is an order for these documents to be produced, so that at trial, when he's cross-examined, points can be made on a proper basis. There's some sense in that, isn't there?
Well, your Lordship,
it doesn't mean I'm making a finding against your client that he's failed to disclose or anything at this stage. It's just when it comes, you don't want to find the uncertainty that, oh, you didn't say there's no order for me to produce this, and so on.
Your Lordship, can I just perhaps maybe invite you to turn up sort of Talim, the case of Talim, and that really gives the test as to the basis upon which a production order should be made. And that should be in the claimant's authorities bundle. Now, there was some to-ing and fro-ing about whether or not the authorities bundle should form part of the trial bundle. We did request the defendants to upload it. So I don't know if you have a copy of the claimant's authorities bundle or not. Hopefully, Mr. Trotter might be able to assist.
I do have, you wait a second. Yeah, Talim, yep.
Talim, it's the case that the former Chief Justice Chadwick presided over. And the relevant, if you have a PDF, it's page 9 on the PDF, but internal numbering page 8. Paragraph 31.
Okay. 31. It's not a very user-friendly report, but yeah, okay, I've got it.
So 31 really starts off in terms of the distinctions between the RDC and the CPR. Yep. 32 is where you have standard disclosure, and sorry, 31 is about the differences between standard production in the DIFC and standard disclosure in the CPR. 32, yep. The parties have a right to request to produce and so forth, and how yep. that process is to be dealt with. 33, 34 deals with the same thing, and 35. If the court decides to order production notwithstanding the objections, then it makes a disclosure order, which requires the party to do one or more of the following things: disclose documents or classes of documents specified in the order, or carry out a search to the extent stated in the order and disclose any documents located as a result of that search. So if the court is persuaded that there may be documents in the possession of the party to whom the request has been made, but that there has been no proper search for those documents, then it may make a search and produce order specifying the extent of the search that has to be made. And the point that I'm making, Your Lordship, is that there has to be some persuasion that there has been no proper search. And we say that in circumstances where Mr. Kahlon has given a witness statement to say what searches he has conducted, that's also underpinned by a witness statement from Mr. Singh of KBH, then in those circumstances, Your Lordship, a proper search has been conducted, and therefore the discretion on you to make a search order, we say, ought not to be exercised, and simply this matter can be dealt with by way of a document production statement that Mr. Kahlon has agreed to provide, and will do so in short order.
The problem that Mr. Trotter points to is that the search carried out by the claimant appears to be a search along the lines of his modified definition of the various categories.
But Your Lordship, that's not correct, because in relation to the categories of documents in the draft order 2.1, 2.2, 2.3 that we've just dealt with, yeah. Mr. Kahlon has searched against those requests.
Well, okay, let's go back a moment to 2.3. Or no, 2.1, 2.3, and we'll take that paragraph from the witness statement, the third witness statement of Mr. Swangard.
My Lord, can I clarify this? Because the position is different in relation to 2.2. In relation to 2.2, the claimant has agreed to carry out the search in the terms that we have requested. And so we don't understand the opposition here, that the formulation is agreed, the order should be consented to, and it ought to be made for good order. Now, there obviously was a concern that there haven't been a proper search because the documents hadn't been disclosed. There remains a concern that there hasn't been a proper search because of the points that I've pointed Your Lordship to, that there remain indications that there are other documents. And if in response to the order, the claimant comes back with a nil return, then so be it. But there ought to be an order so that there is such a search and obligation.
Your Lordship, just to continue with my submissions, can I also then invite you to turn to Mr. Kahlon's witness statement to see exactly what he says about the searches that he's conducted? It's at page 485 of the bundle.
485?
Yes.
What number of statement is it of his?
It's Kahlon 3, I think. Sorry, Kahlon 4. Yes, Kahlon 3, 485.
Yeah.
And it's paragraph 21.
Yeah. I have therefore, without waiving privilege.
Yes, carried out a reasonable search for the documents in my possession, custody and control. And then if I go down to
Yeah.
and here at 24, he deals with the ArcelorMittal stock option documents. And paragraph 25, he deals with 2.3 of the order.
Yeah.
And
Where does he
20,
deal with 2.2?
beg your pardon?
Where does he deal with 2.2?
2.2, he deals further down, rather up, sorry, at 25. It was always envisaged.
That's 2.3, isn't it? The resignation from ArcelorMittal.
So 24 is 2.1, the ArcelorMittal stock option documents. 25 is
The resignation documents.
yes.
What about 2.2? Communications with Mr. Marwar. Does he deal with that?
He does deal with that, maybe not in this section, or I can't find it in this section, but he deals with it further down in any event. The DPO application.
Yeah,
He deals. I think it's taken more chronologically. If we look at paragraph 54. So 54.1 deals with 2.1.
Yeah, and he says he'll produce these.
And he has produced
2.
them. And documents at 2.2 he produced on the 17th of January.
Yeah. So as Mr. Trotter says, he doesn't object to the category. He says he's produced them. As Mr. Trotter says, there don't seem to be very many, rather surprisingly. And he's pointed to some reasons for thinking there should be more. What's wrong if he doesn't object to the category? What's wrong with the order?
Well, Your Lordship, the order we say is that if one looks at Talim, that's if there is no reasonable search that's been conducted. And we say that he says in terms he has conducted a reasonable search. Yes. I appreciate that there is a different point of contention as to who should have conducted that search.
Yeah, but Mr. Trotter points out in his witness statement, in his skeleton argument, that there's basis for thinking that there should be more documents. If there aren't, there aren't. But the important thing is that the individual, the claimant, knows that he is under an order of the court to produce these things, and if he says he's complied, then so be it. He can be cross-examined if it's thought he hasn't. But without such an order, the cross-examination is ineffective or less effective. I mean, we seem to be arguing about nothing.
Your Lordship, I wanted to draw your attention to Talim and the point in Talim.
You've done that. Yeah.
I've done so.
I don't think that Talim says that you don't make an order if there's reasonable grounds for thinking there should be more documents.
Well, Your Lordship, the point is that in my submission, Mr. Trotter hasn't pointed to any reasonable grounds. He simply says that we think there should be more documents, but there aren't. Okay,
if that's the argument, I've made a decision on that. I think Mr. Trotter has pointed to a basis for thinking there should be more documents, and if there aren't, there aren't. Right, Mr. Trotter, 2.4.
Thank you, my Lord. 2.4 should follow a fortiori from Your Lordship's decision just now. If we stay in the same witness statement of Mr. Kahlon at page 493 of the bundle,
Can you give me a paragraph number? Sorry, I'm looking at it as a
Yeah.
separate document.
I see. Yes, it's 54.4.
Yeah, okay.
So the defendants seek an order for production of communications sent and received by me on the 27th of May. That's the day, my lord, when he says he signed the pivotal contract without reading it because he was too busy.
Yeah.
I consider this to be wide, but I'm willing to conduct this search subject to parameters and so on. So the issue is agreed. There's some question about parameters, but there's been further correspondence since then. We received a letter from our learned friends yesterday afternoon confirming that the narrowed formulation which we proposed was agreed. That is in the supplemental.
Before noon, is that right?
I'm sorry?
Is a narrow formulation the one that says before noon on that day?
Yes, I think that's right, my lord. And so that is agreed. Some screenshots have been produced, but that seem to have been screenshotted by the claimant from his phone. But the claimant has agreed to produce the emails themselves if so requested. We do so request, and so it should be straightforwardly a matter of making the order.
Right. Ms. Ahmed, is there any difficulty about this one? With the limit to before 12 noon on the 27th May. I think you're muted. Sorry, I've only noticed your lips were moving.
I beg your pardon, Your Lordship. May I perhaps make an overarching submission? Firstly, Your Lordship, we say that this application was premature. Secondly, by virtue of this witness statement that you've been taken to, this was filed on the 15th of January. We say that this would have resolved more or less all the issues. The third issue is, and particularly with Article or Clause 2.4 of this order, in terms of what they're seeking, 27th of May 2020. Now that's the date that Mr. Kahlon signed the 5th of September letter. The issue with the 5th of September letter is that the claimant says that he signed it by mistake. He said he was travelling, and he doesn't go any further than that. And so what my learned friend is seeking to do is try and work out what the claimant was doing on that day that led to this mistake. And we say, in principle, that actually there is no probative value with considering what the claimant was doing on that particular day, because there isn't a pleaded case that because, for instance, he was sick, he made a mistake. He simply says that he was travelling. And so therefore, as a point of principle, notwithstanding what's been said in the witness statement, as a point of principle, we say that there is no probative value in trying to investigate and interrogate what messages the claimant may or may not have been sending on the 27th of May 2020. Be that as it may, Your Lordship, in the witness statement, we have said, or the claimant has said, that he'd be willing to search for documents. And Your Lordship, we have tried to close this issue down by, I think the KVH, the solicitors, looked at the claimant's mobile. There are no communications that go to any evidential value of what happened on the 27th of May. They've sent screenshots of what was on there. I mean, the defendants themselves have said in correspondence that they're not concerned with the subject matter of any of these messages. And so, Your Lordship, I'm not sure how far or where this goes to and what the point is.
Well, if he's willing to give them, or says he has given them, then there's no harm in having or sensible to have the obligation set out in a court order, so that his performance can be measured by reference to that obligation. That's leaving aside who should conduct the search point.
But Your Lordship,
it's the same point as at 2.2.
Well, Your Lordship, it's not, because it doesn't go to performance. It simply goes to why it was that the claimant signed the 5th of September letter, which omitted the LTIP. You'll recall in this case, Your Lordship, that there are two letters. One that includes the LTIP, the second one that the claimant says he mistakenly signed excludes the LTIP. And what the claimant says in his pleadings is that he signed it by mistake. He doesn't give any reason as to why. And what the defendants appear to be doing is asking for communications up to noon on the 27th of May to try and work out whether or not there is any contemporaneous evidence of the mistake. Well, Your Lordship, first of all, one can't see any probative value in interrogating any communications on that date as to whether or not or how it was that the claimant came to make the mistake. I mean, there's no pleaded issue.
I thought the point was simply for the claimant to be able to, the defendant to be able to check how busy he was and how active he was on his mobile that day, to provide the context in which you can judge whether he's likely to have had time to avoid making a mistake. But
Well, I'm not sure that they formulated it like that. I think the way in which they say, and there's a letter to this effect, that, do you have a reference to that? There is a letter to this effect, Your Lordship, whereby they say that they want to see the claimant has said he was travelling, and they want to look at the communication. I mean, the futility of the exercise is that they want to look at the communication as far as we understand, and work out. Basically, I think they've said that all communication sent and received by the claimant. I mean, they haven't gone any further as to why that might be necessary, why it might be relevant, what the probative value is in addressing the pleaded issue of mistake. I mean, especially in circumstances where the claimant hasn't pleaded any alternative reason as to why there was a mistake, and therefore the defendant's request in this nature is just, quite frankly, quite broad. I mean, it's too broad, we say. We say that there's no logical or evidential basis to suggest that communications, irrespective of their content, would bear upon the claimant's state of mind or the circumstances leading to the alleged mistake. And so, Your Lordship, to close this down, the claimant has given a screenshot of communications on his personal device, which was what was requested by the defendants. They also said in their request that they aren't concerned about the content. And so, Your Lordship, to now want to see whatever was on his device or the content of the screenshots is I mean, it's an absolute fishing expedition. It's a fundamental misunderstanding or a deliberate distortion of the claimant's case, because the mere act of communication, Your Lordship, can't provide any insight into the existence of a mistake.
Well, that's a judgment to be made.
I beg your pardon?
That's a judgment to be made, whether it provides an insight or not.
Well, Your Lordship, how does,
I can't just take it from one side that it won't provide an insight. We don't know, we haven't seen necessarily all the documents.
Well, Your Lordship, there's no discernible link to any pleaded point in the case. The claimant simply says that he was travelling and he made a mistake.
Yeah.
I mean, the letter itself is at page 1352, paragraph 2.
Yeah. Yes.
They say at paragraph 6, the relevance of this request does not concern the subject matter of the communications, but rather the fact that there were such communications and what they reveal about the events of the day. It is therefore not appropriate to filter the documents by keyword. Moreover, given that the request concerns communications in a single day, we do not expect the exercise would be disproportionate. And so if they say that it doesn't concern the subject matter of the communications, and we've provided a screenshot of said communications on that day, it's now a stretch from a learned friend to then request now the subject matter of those communications.
So what do you say you've given without the subject matter?
We've given them screenshots
of
the communications. I think it's in the supplemental bundle that was sent to you.
Yeah, do the screenshots not contain the subject matter?
I'm just going to bring it up. I think they've been redacted. I think what it shows is the date on which they were sent, the timing, and the recipient. And it's in a supplemental bundle that was filed by the defendants.
Yeah.
Page 19 and 20.
Yeah.
And what page 19 shows?
It's all black.
Yes, so the content
Yeah.
has been redacted, but what they show
So-
is the recipient.
So no timings even.
But they've got dates, Your Lordship. So this is a screenshot
Come
of
on,
the
look,
device.
Miss Ahmed, we'll waste a lot of time. There's no basis, as I can see it, no confidentiality basis or anything else for refusing to give these documents. Unless you've got some point you haven't raised yet, I'm going to include them within whatever order I make as to production. Right. Mr. Trotter, do you want to go on to 2.5?
Thank you, my lord. 2.5, I'm hoping will be a low-hanging fruit as well. This is, in a sense, the other end of the telescope. So first we're looking at what was going on when he said he made the mistake. Now we're looking at what happened when he discovered it. Because if he'd been tricked into signing away $30 million, then just imagine the outrage that would have been expressed when he found out.
I think Miss Ahmed may have disappeared. I don't want to go on in her absence.
Oh yes, quite right. I had those.
So did you hear what Mr. Trotter said?
I did, Your Lordship, yes.
Yeah, thank you. Yes, carry on, Mr. Trotter.
Yes. So what one would expect there to have been a moment that came where he discovered that he, on his own case, had been tricked into signing this letter. And he does say that it's egregious and deliberate conduct in his pleading.
Yeah.
And one would expect all sorts of expletives to be sent to anyone who cared to hear them. And so we've made a request for any communications in two periods. One, following the date of his purported discovery, whenever that was, and second, from June to August 2020. Now, the reason we've expressed it in that way, and I don't need to turn it up, is that my lord might remember that we served an RFI about this and asked him to tell us when it was that he discovered the mistake. And he has declined to answer that and said that we'll find out for the first time in witness evidence. And so that's the best we can do in terms of framing it.
Why didn't you press for an order?
Well, my lord, in a sense, we didn't think it was proportionate to do so, but it doesn't preclude us from formulating an issue in this way, because of course he will know when he made the mistake, and he can tell his solicitors, and his solicitors can conduct a search.
Yeah,
now,
okay.
In a sense, again, this should be a low-hanging fruit because it has been agreed in principle, but if one just looks at the terms in which it's been agreed, if we look in the hearing bundle at page 493, and we're now in paragraph 54.5.
Yeah.
He says, we seek an order for production communications sent in two defined periods. I have already conducted a reasonable search for such communications, but no documents were discovered. But then this, that is not surprising because during my employment, I was labouring under a mistake. Now, our concern about that, my lord, is that it indicates that he's only searched for communications during his employment, because the explanation he gives for the absence of any documents is that he continued to labour under the mistake during the terms of his employment. Now, it may be...
Can you remind me, when did his employment start?
His employment finished, or started in, at the earliest in January 2020. And it finished, more importantly, in May 2022. And my lord will remember that most of the searches, most of the date ranges in this case, have therefore been formulated by reference to an end date of May 2022, with certain very limited exceptions.
Yeah.
Now, it may be that Mr. Kahlon has therefore limited his search to May 2022, and we infer that from the explanation that he gives, because he says the reason that no documents were discovered was that I was still under a mistake during that period. But my lord, that's a misreading of the request, because the request is concerned with whenever he discovered the mistake, whenever that was. Now, he will know when that is, but what we're looking for is the communications, if they exist, in the period when he discovered it. Now, again, we're in the same territory, because if he comes back and says, well, there are no such documents, then we will make a point about that at trial. But we need it to be absolutely clear that he has an obligation to search for those documents whenever they might be, not limited by date range. So again, my lord, I say it's a fortiori from the rulings that your lordship has already made.
In terms of 2.5.1, the period could be a day, could be a year, depending on when he says he discovered the mistake. Should you not limit it to a few days after discovering the mistake?
I understand that point, my lord, and perhaps it could be, well, one can imagine the shock might take a little while to sink in, even if it would, say, 2 weeks after he discovered the mistake. That would be a very confined period of time.
Okay, Ms. Ahmed.
Your lordship, a couple of points. I mean, picking up from what Mr. Trotter said at the end, if he says he doesn't have documents, then so be it. Well, he says exactly that at paragraph 54.5 of his witness statement at page 493. He says, the defendant seek an order for the production of all communications sent and received by me regarding the 2nd, 5th of September letter for 2 defined periods. I have already conducted a reasonable search for any such communications, but no documents were discovered. This is not surprising, because during my employment, I was labouring under a mistake that the terms and contents of the 2nd, 5th of September letter was the same as the 1st, 5th of September letter. The admitted position at paragraph 47.2 of the defence is that Ms. Timms altered the 1st, 5th of September 2019 letter to remove reference to the LTIP and the annual bonus. Yet, as far as I can ascertain, the defendants have not produced any documents relating to when the decision to alter the 1st, 5th of September letter was made, or the reasons why the decision was made, nor have the defendants produced any drafts of that document. The lack of disclosure on these points is striking and raises questions about the completeness of the defendant's own document production process. Given the material significance of these alterations, the absence of supporting documents from the defendants is highly relevant and warrants security. So the claimant has said that he has conducted a search and he doesn't have any documents. The second point is in terms of the date range. Mr. Trotter takes umbrage with the fact that he's misunderstood the request because he's made a search during his employment. Employment was terminated on the 9th of May 2022. He's already given evidence that he downloaded, I think in this witness statement, he downloaded documents in contemplation of the defendants terminating his employment. And he says it in this witness statement somewhere when he talks about a meeting with Mr. Ollier in April or thereabouts, and I can find the relevant reference for you. And the point there is, your lordship, so as early as April, his employment was terminated on or about the 9th of May 2022. So in April, he envisaged a dispute, and therefore we say everything after that probably attracts privilege because there was a contemplation of litigation. But be that as it may, your lordship, the claimant has conducted a search and has provided everything that he is able to provide, and he doesn't have anything in his possession, custody and control on this point.
Well, it does seem to me that Mr. Trotter, there's some force in Mr. Trotter's point that his focus seems to be on looking at communications during his employment, which is not really the point. So I'm minded to make an order with the qualification that I added to Mr. Trotter's 2.5.1 to say the period of 2 weeks following the date of the purported discovery. I'm minded to make an order in terms of 2.5.
Thank you, my lord. Next is 2.6.
Yes.
2.6 is, I'm afraid, a bit more contentious, not amongst the low-hanging fruit.
Yeah.
Now, my lord will remember this issue from the last occasion.
I do.
And my lord will probably remember how it arises on the pleading, so I may not need to take your lordship through that again.
Yeah.
But I'm happy to if it would be of assistance.
No, I'm satisfied I know enough about it on the pleadings.
Thank you, my lord. Perhaps I ought to just show your lordship just some documents to set out the chronology of this because it affects the date range for the request.
Yeah.
Your lordship will have seen some of them before, but I think we can do this quite quickly. If we look first at page 1409 of the bundle.
The bundle. Yeah.
So this is Mrs. S's CV. One sees that she was a graduate under education. One sees a graduate of law in 2017.
Yeah.
2016 to 2018, straight after graduation, indeed beforehand, was working with ArcelorMittal effectively her whole career.
Yeah.
Obviously also the same place as the claimant. If we then just go back a page to 1408, we see how it was that Mrs. S came to be employed at Liberty.
Yeah.
Now, the next year, one page turns to page 477.
Sorry, 477.
Yes, my lord. Again, the internal numbering of this bundle is out. So it's 425 on the internal numbering, but 477 of the PDF.
Yeah.
Or perhaps that's just my version. Anyhow, one sees here a letter from the claimant to someone else within Liberty Steel. As discussed today, you can proceed with appointing Mrs. S as Manager of Compliance and Contracts. So that's October 2021. Claimant arranging an appointment or being involved in an appointment to a particular position. And then at page 468,
yeah,
my lord will recognize this email. This is, so we're 6 weeks on now, 6 weeks after the appointment to her new position. Then if one goes to 479, does my lord have that?
Well, 1 second, can you? Yeah.
So this is, we're now in January 2022. So we're just a few weeks after the pregnancy email.
Yeah.
And one sees the middle email on that page from the claimant.
Her salary need to revise. She is lowly paid.
That's right. So we need to pay her more. That's a few weeks after he's told that she's pregnant. And then finally, a month later, we have it 469.
Yeah.
We're now February 2022. So 1 month after she has, well, the claimant has attempted to revise her salary up. And we have this email, which my lord has seen before. And my lord knows the characterization that we would place on this email, although it will be obviously contentious. So that's how the issue arises. Now, there have been disclosure requests about this very issue by the claimant himself. And so we are surprised that this is controversial. If one looks at page 1231 of the bundle, this is a letter from KBH in November of last year. If one sees under the bold heading, paragraph 2, it said paragraph 75A of the amended defence pleads, and then there's a quote about the pleading of the romantic relationship. Paragraph 3, the specific production does not appear to include documentation that relates to that paragraph. Of course, saying we don't accept that at all because the documents that my lord's just seen, 2 of them were disclosed in July of last year. But in any event, our client now makes the request 3.1, all documents and communications between the claimant and Ms. S.
Yeah.
Now, if we then go to 1259.
1359.
1259, my lord.
1259, yeah. Yeah.
This is another letter from KBH on the 16th of December. If we look at paragraph 4 of this email, it's referring back to the letter that we just saw. Again, it said the defendants amended their defence at paragraph 74A, that should read 75A, to introduce new grounds. It's clear that we've not been provided with the documents related to those pleadings. We repeat our requests that those documents are provided, so KBH are reiterating the same request.
Yeah.
And then 1263.
Yeah.
So at the very bottom of that page, this is our response. Paragraph 3 and 5 of your November letter requested that we produce, and then over the page, 7.1, all documents and communications between the claimant and Ms. S. And then paragraph 8, we agree to conduct a proportionate search for and produce the documents you've requested, except for a different category, which is not relevant for present purposes.
Yeah.
Then paragraph 10 of the same letter, we request that your client produces the same category of documents insofar as within his possession or control. Please confirm the date by which he'll do so. And in a sense, we thought that would be uncontroversial, because if anyone's going to have these documents, then it will be the claimant.
Mm-hmm.
Now, my lord will remember that this issue has become particularly acute because a dispute has emerged about the authenticity of the emails that we have produced.
Yeah.
Now, it's not quite clear exactly what the nature of that allegation is, but one way or another, it's suggested that those documents are not genuine.
Yeah.
And my lord will remember that from last time. I don't think I need to go through all of the documents and the transcripts and so on, but that my learned friend's instructions were he doesn't recognise those documents and he was not party to them. And that's set out to similar effect in various letters and in evidence. So, my lord, the claimant has specifically sought disclosure of his communications with Ms. S. He's indicated that he will challenge the authenticity of them, mainly on the basis that there are no other communications of a similar kind. And he says the documents lack sufficient context and are misleading.
Yeah.
Now, in those circumstances, we find it frankly bewildering that the claimant is resisting an order that he also search for such documents. Yeah. He will not search for them, much less will he agree for his solicitors to search for them.
Yeah.
Now, we see what Mr. Kahlon says about this in his witness statement. It's at 493 of the bundle. We're back on this familiar page.
Yeah.
The paragraph 54.7. So just to unpick this, there's really 3 points here. First of all, the defendants seek an order for the production of the communications between Ms. S and I between those dates. These were the first point is this: they were requested by the defendants a mere 3 weeks ago. That objection about timing has understandably not been pursued in my learned friend's skeleton argument. The second point is this is nothing more than a fishing expedition. We don't understand that objection either. There is obviously reason to believe that such communications exist. It's the same request that my learned friend have made of us. and it does not feature in my Leonard skeleton argument either. And then finally, this point, in any event, if any relevant documents do exist, they will be on the Liberty devices which the defendants have in their possession or control.
Yeah.
Well, my lord, there is no reason at all to think that all of the communications between the claimant and Ms. S are within our control. There are obvious reasons why Mr. Kahlon will have kept his communications with Ms. S separate from his Liberty devices. And it's just not enough for the claimant to simply assert that that is where they will be and to refuse to conduct a search elsewhere. Now, if he's ordered to do so and he comes back with a nil return, then again, we will have quite a lot to say about that at trial. Now,
Yeah.
In any event, Mr. Cullen's position is not that all of his communications during his time at Liberty were conducted uniquely through his Liberty devices. That would, of course, be a very surprising position, but that is not his case, and it is demonstrably not the case in any event, because we have identified from the disclosure various other ways in which Mr. Kahlon communicated during that period. I'm going to show my lord some of those. First of all, 1251.
Yeah.
The very bottom of that page, paragraph 4.3, this is a letter from KBH. The iPhone, the iPhone there is a reference to the Liberty iPhone, was used by our client as a personal second phone until September 2022. So there's confirmation there that there was a second phone. That's one possibility. Next, my lord, more recently in the supplemental bundle, at page 13 of the supplemental bundle.
Page 13.
Yes. PDF page 13, it's internal page 12.
Yeah.
And so under the heading 27 May 2020 documents, we've already covered this specific request, of course, but the very bottom paragraph in that section, paragraph 13, with respect to his personal mobile phone, our client confirms, and KBH can also confirm, that he did not send or receive any SMS or WhatsApp messages on that date.
Yeah.
So here we have a personal mobile phone. This is the first we've heard about this. That is searchable on that date in 27th of May 2020, and which KBH could confirm that there were no SMS or WhatsApp sent on that date. So that's another possibility. Next, if we just go back to the application bundle again, at 1294. The very bottom of that page, one says Roman numeral 2.
Yeah.
WhatsApp chats stored on a mobile phone used for both personal and work, over the page, work purposes, containing a UK SIM card pertaining to that device, which was replaced in 2020, defined as the UK iPhone. So there's a third phone. Well, of course, we don't know whether some of these personal phones are the same thing or not, but there's a third possibility there. Now, we've asked, what was that replaced by? And we've never had an answer to that.
Yeah.
Next, page 258.
258.
Yes.
Yeah.
This is a WhatsApp string, but one sees towards the bottom of the page.
258 of the document or the bundle?
258 of the bundle.
A whole lot of stuff in square brackets and so on.
Yes, my lord. So this is an extract of an unrelated WhatsApp chain of messages between two people. In a sense, the context of this document is not important. The part I want to draw attention to is about 10 lines up. Does my lord see a message sent at 3:12:01?
Yeah.
And it's common ground. Yeah, it's common ground that the phone number ending 316 is a phone number of the claimant. So this is the message sent by the claimant in February 2021, and he's referring to his cell number in India. So there's an Indian mobile phone as well. And again, we've asked about this in evidence. I can take my lord to it. I don't think it's necessary. There's been no response to our questions about that.
Yeah.
Now, to be clear and fair, there are some WhatsApps that were downloaded from the UK iPhone, so from one of the 4 devices I've mentioned, onto the personal hard drive. And some of those WhatsApps have been produced, but they are incomplete so far as concerns this issue. One looks at 1294 of the bundle again.
Yeah.
This is back where we were before, but if we look at paragraph 12, the claimant is here referring to the personal hard drive, and we're told in subparagraph A that sometime prior to April 2022, the personal hard drive contained, and then Roman 2, WhatsApp chats that had been stored from the UK iPhone. So there had been some WhatsApp chats that were on the UK iPhone that sometime prior to April 2022 were downloaded onto the hard drive and have been produced. But if one then goes forward to page 1296, paragraph 25C, we're told what the scope of those UK WhatsApps are, and they are limited to WhatsApp chats prior to the 1st of January 2021. And of course, 1st of January 2021, as my lord will have from the chronology we looked at earlier, is nearly a year before the pregnancy email.
Yeah.
So the WhatsApp chats that have been produced, such as they are, do not relate to at least the whole period. But in any event, they don't relate to the full range of devices.
Yeah.
And moreover, it's not just WhatsApp we're talking about, because my lord saw a moment ago in the letter that KBH had looked at WhatsApps and SMS messages from another phone. And then just to add to that same picture, if we look at page 315 of the bundle,
yeah,
here we have another one of these WhatsApp strings, but now I'm interested in around the middle of the page. Does my lord see it 7:56:15?
Yeah.
There's a message from the claimant. Do you have Telegram? Now, Telegram is another messaging app.
Yeah.
Yes, I have. And then further down, about 5 lines down, Telegram calls not working. I tried Signal as well. Response, I have Signal too. That's another messaging app.
Yeah.
So far we have several potential phones, which may encompass several forms of messaging service, which are not in any sense covered by the disclosure that has been given.
Yeah.
Now, it doesn't stop there, because there are also various email accounts. One looks at 806 of the bundle. This is the claimant's DPS. One sees at 3.2.4. There's a reference in brackets to my personal email accounts, plural.
Yeah.
Now, of course, only the Yahoo account has been searched, and my lord will have picked up that the claimant's pleaded case is that he only rarely used that account. And my lord heard a fair bit about that earlier. Then, now, of course, we don't know exactly what email accounts he uses, but we have identified some. First, page 33.
Yeah.
And one sees at paragraph 41.4, the defendants have identified at least one other, a Gmail account.
Yeah.
And that is given there. That's the first possibility. Then the next paragraph down, the claimant has also indicated he has an iCloud account. And if one looks down at 41.5.3, I understand an iCloud account, and my lord may be familiar with this, can encompass various things, but it can include an email account.
Yeah.
One then looks at 1270 of the bundle.
So 1270.
Yes.
Yeah.
Paragraph 13.3 towards the end of the page.
Yeah.
This is our letter, and we're asking, please explain, does your client have, or has he ever had, an iCloud email address?
Yeah.
And then we get a response at 1296.
Yeah.
Paragraph 24 in the middle of the page. Your request relating to the content and nature of our client's iCloud account is rejected, so he will not tell us whether he had an iCloud account or not as an email, but he does tell us that it was required for the purposes of operating his Apple devices. So there must be some other Apple devices that we don't know about. But my lord, we, in the light of that letter, have done some further digging, and one sees at page 1414 of the bundle.
Yeah. Yeah.
This is an email sent from the claimant's Liberty Steel Group address to Mr. Gupta in May 2022. And my lord sees the address that it's carbon copied to is an iCloud account. So there certainly is such an account as well.
Where's the iCloud account? Oh, sorry. Yeah. Okay. Yeah.
Yes.
No, it's okay.
CC. Yes. Now, just to complete the picture, There is, of course, the Yahoo account as well. We've been asked, my Lord will have picked up that KBH have now been given access to the Yahoo account. They've asked us for some keywords, and we've asked them at 1355 of the bundle to include Mrs. S, her email address as a keyword.
1355.
1355.
Yeah.
I'm sorry, not as a keyword, as a sender or recipient. Does my Lord see 32 in this table?
No. Oh, yes, I see. Yeah. Yeah.
And if my Lord goes to the supplemental bundle,
yeah.
at page 14, paragraph 18, I should say this letter comes, I think, 5 days after our letter. We are taking instructions in respect of the proposed senders and recipients. So there's no agreement even in respect of...
Hold on.
I'm so sorry.
What page am I on?
The supplemental bundle.
Yeah, page
14 of the PDF. 13 internally.
Okay, sorry, I see. Yeah.
Paragraph 18.
Yeah.
We're taking instructions in respect of the proposed senders and recipients that we'd suggested.
Yeah.
So the point I'm making here is, of course, in light of all of the other repositories I've taken your lordship to, we do not accept that a search of the Yahoo account is going to be sufficient. But even in respect of the Yahoo account, there's no agreement, at the moment at least, to search for these communications. And yeah. I should say none of the other sources that I've taken your lordship to have been included in the claimant's disclosure search, and there's no agreement to include them. Now, my lord, it's just completely unsatisfactory for the claimant to assert, in light of everything that I've just shown your lordship, that the only communications with Ms. S will have been done on Liberty devices. Yeah. But my lord, it goes further than that, because even on the Liberty devices, before returning them, the claimant removed his iCloud account from those devices. I show your lordship that it's back in the bundle. 1251.
Yeah.
So at the bottom of the page, paragraphs 4.2 and 4.3.
Yeah.
We're told that the iPad hasn't been accessed since May 2022, except to remove his iCloud account. Similarly, 4.3, the iPhone was used until around September 2022. Our client has since then removed his iCloud account from the device. Yeah. Now, we asked when that was done. The claimant did not tell us in response, but at some point between mid-2022 and when the devices were returned to us late last year, the iCloud account was taken off the Apple devices. And your lordship will, I'm sure, know that when one takes an iCloud account off devices, it takes with it all of the material associated with the iCloud account.
I see, yeah.
And that is effectively a cloud storage facility, includes emails and whatever else one uses within the iCloud. And the claimant will still have those documents wherever they are. So, my lord, in a sense, none of that matters because we don't accept that it's sufficient for the claimant simply to assert that there was nothing outside the Liberty devices. But even if that was the case, that would provide no comfort at all. And so, my lord, clearly there's no dispute about relevance because the same request was made of us. Clearly, there is reason to believe that he has such communications in his possession because of the documents your lordship has seen and because he is the counterparty to those communications. And there are various places that they could be. And your lordship, I invite you to make the order to require him to search. And as I say, if he comes back with a nil return, then we will have something to say about that at trial.
Yeah. Very well. Miss Armit.
Your Lordship, my learned friend asks the question, what's the controversy with all of this? I mean, maybe I haven't made this clear, but there's never been any controversy. The whole point is, Your Lordship, that the claimant is saying that this is a colossal waste of time and money because he has, and I hope with all the letters that my learned friend has taken you to, he has engaged and grappled with these requests that the defendants have been making. And my learned friend has taken you to some documents. And maybe, Your Lordship, if I can invite you firstly to take you to the document that he has already taken you to, and that's a letter written by KBH on the 22nd of January. It's at page 11 of the supplemental bundle.
Yeah.
And it's not a question of the claimant saying that he's objecting to these or that there's controversy or that he won't do a search. He simply said that you should have given me the opportunity to deal with all of this in correspondence. And at page 11, he says at paragraph 3, having sat on our, the KVH say, having sat on our client's objections to the RTP, which was served on the 27th of October, having remained silent on our client's production, which was served on the 15th of November, you belatedly in your letters dated 19th of 20th of December raised a significant number of matters raising questions about our client's document production, part A and part B, and that's a letter you've already been taken to. And that's at page 1268. Going back to the letter at page 11, this was unrealistic given the holiday period and because the claimant was being forced to grapple with the defendant's tardiness in respect of production, forcing him to make an application to court. Notwithstanding the above, you were sent a letter on the 21st of December addressing the Part A queries, and that relates to the scope of the searches, and were informed that the matters relating to Part B were being dealt with. Part B was the granular request that you see at section 2 of the order. Without affording our client a proper opportunity to resolve your Part B request, you prematurely issued the application 7 days later on the 7th of January 2025, causing unnecessary chaos and adding extra layers of work to an already contracted timetable. This approach is entirely unnecessary, disproportionate, and a colossal waste of everyone's time and costs. And this is how the claimant has sought to deal with these requests. And the first time this request in relation to these documents was made, it was buried in a 6-page letter in one paragraph, a 3-line paragraph, and that's dated the 19th of December at page 1262.
We'll turn that up.
You've already been taken to this.
1262.
Yes, it starts at 1262. You've already been taken to this letter in paragraph 10 of this letter. And the early parts of that section deal with the request, the specific production request made by the claimant in the context of the pleaded case, and that is that the claimants, or rather the defendants, are alleging some sort of misconduct. Pausing there a second, the claimant's employment wasn't even terminated for misconduct. It was on the face of it terminated for a reorganisation exercise. But be that as it may, what the defendant has requested in that 3-line paragraph, we request that your client produces the same categories of documents insofar as within his possession or control. Please confirm that he will do so and the date by which he will produce those documents. And that's really the first time we see that request before the application is issued. In terms of the defendants dealing with this then, the defendants write back on the 20th of December, I beg your pardon, on the 20th of December, there is a further letter by the defendants, and that's at page 1268. And Part A, as I said, deals with the scope of the document production exercise. And my learned friend's argument is, well, there are other repositories and accounts that ought to have been searched. And my point is this, that the claimant has been grappling with all of this extensively, particularly in relation to the questions that have been asked. So at page 1269, paragraph 10 deals with laptops, iPad and phone. KBH deals with it on the 31st of December at page 1294. At paragraphs 6, 7 and 10. And 6A to C, these are all Liberty devices, and those have been returned to the defendants. In any event, the claimant says that everything that was on these devices was then downloaded on his personal hard drive. And then he talks about the personal hard drive at paragraph 7, and then he refers to the Yahoo account. In paragraph 10, he refers to providing a document, revised document production statement to set out the scope of his searches and where he has searched.
Yeah.
Paragraph 23, and you've been taken to this by my learned friend, he talks about the iCloud accounts being removed from the iPhone.
Mm-hmm.
But in any event, again, at paragraph 10, I go back to his position at paragraph 10, he commits to revising the DPS after addressing the additional queries.
So where does that leave the iCloud accounts?
Well, your lordship, the iCloud accounts, I mean, the point I'm making is, your lordship, that all of this, or rather the KBH, has said in correspondence subsequently that it will search the hard drives, it will search the Yahoo accounts, it will search any other accounts that the defendants have brought to the claimant's attention. And so, your lordship, the point being that this is a bit of a needless exercise, because KBH has said, or the claimant has said, that he will allow access to KBH to review the hard drive and review the Yahoo accounts.
And your lordship, email accounts?
I beg your pardon?
And the other possible accounts?
Your lordship, I think there has been instructions about the Gmail account. I'm sure if the claimant is willing to give access to the Yahoo and the Gmail account, that there'll be no obstruction in relation to the iCloud account. But obviously, your lordship will have to take instructions on that. My instructions are that the claimant can't access it anymore.
Well, then that is exactly why you need an order, so that he can say that on oath, and then be cross-examined on it. Well,
your lordship, he has suggested that he'll provide a document production statement that will set that out. It's not necessary for an order, given on the 31st of December, he has said he'll provide a document production statement. In January, he said he'll provide a document production statement.
Mr. Ahmed, I'm sorry to interrupt you. What is the problem with including this 2.6 within an order?
Your lordship, it's an overarching submission in relation to all these requests. There is no objection in principle, given that the claimant has already agreed to provide a document production statement.
Why are we taking so long if there's no objection in principle?
Well, your lordship, the reason why we're taking so long is that this application should never have been brought in front of you. The claimant has always accepted and acceded to these requests. He said he'll make a document production statement.
I've been shown material which seems to me to be potentially equivocal. I will only know whether it was or not later on, but it does seem to me that people saying, "Oh, we'll look at this, we'll try and find this," and so on. It's much better to have an order. Then their performance can be measured against what they're meant to do by the order.
Well, your lordship, if I was the claimant, I'd take some issue with that, given those are exactly the precise points that the claimant was making in his application, where my learned friend was saying that everything had been swept up in a search and therefore that it was not necessary to make a document production order. I mean, the situation, I'm not sure is
we did order a document production order in the end. Last week or the week before.
Your lordship, in principle, the claimant has no objection to making a search of these documents. In principle, the claimant has no objection to providing those accounts that he has access to his solicitors. And your lordship, it may be that this is a point on costs, But
if for example he says he can't get hold of the iCloud account, contents of the iCloud account, he will no doubt say that and say that on oath in the document production statement.
yes, Your Lordship, and he will say that. He's said that. I'm not sure about the iCloud account, but everything else he said in his witness statement that he's provided in response to this application.
Okay.
And Your Lordship, there is no difference between what is said in his witness statement to what he's agreeing to do in any event. And so, Your Lordship, I suppose the point is that in principle he doesn't have any objection, but he has an objection when it comes to deciding the issue of costs.
Okay.
And it may be that we can short circuit this and say that he is, in all of the categories that have been provided for in this draft order, he has conducted searches. He's willing to conduct further searches. He's willing to conduct further searches of the repositories that my learned friend has referred to. He's willing to provide a document production statement. He has no objection to that.
Right. So are we then content? Can we shortcut it on that basis and make the same order in respect of 2.7, 2.8, and 2.9 and 2.10?
On the proviso, Your Lordship, that he has already conducted a reasonable search, but he's willing to conduct a further search by his solicitors.
That's what he says he's done. But yes. 2.10, I think, was modified slightly and restricted to tax returns and bank statements.
Well, Your Lordship, we do object to the tax returns because we don't see any probative value of that. Your Lordship, he has given all financial records relating to any income. I mean, this is a question of mitigation. The burden's on him to prove that he's mitigated his loss in any event, and therefore we don't see any evidential value or probative value of the defendants wanting to see his tax returns.
What can be the objection to tax returns when an issue in the case is what he's earned since ending his dismissal by the claimant, by the respondent, defendant, sorry.
Yeah. Well, Your Lordship, I think in the first instance in this jurisdiction, the claimant doesn't have to file any tax returns.
Well, then that may be the answer. I mean, let's cut to the chase. Let's not argue about something you say doesn't exist.
Fine, Your Lordship, I'm happy on that basis.
Mr. Trotter, I think there is agreement, not necessarily enthusiastic agreement, but agreement to the terms of 2.7, 2.8, 2.9, and 2.10 with the qualification I think you mentioned in your skeleton, which is limited to tax returns and bank statements. Are you content to proceed on that basis?
That's very helpful from my learned friend. There are 2 points that I just need to make abundantly clear because my lord will have seen that there was some dispute about the terms of Your Lordship's order on the last occasion. But the first point is this. It is very helpful that my learned friend has said on her feet that there's no opposition to the production of the communications with Ms. S. But it was said that had always been the case. And because my learned friend specifically said that it would be raised on costs, I should just address that now while it's all fresh in everyone's minds rather than having to come back to it later. Because my learned friend has gone into print 3 times on this question and has opposed the request on every occasion. And can I just quickly show Your Lordship that, because I don't want Your Lordship to be left with the impression that this is something that was just agreed to and that we needlessly pressed for. It's first of all, page 493 of the bundle.
Yeah.
This is the claimant's evidence in response to our application, paragraph 54.7. My lord's already seen this paragraph, but just to remind Your Lordship, this is the claimant's position in respect of this request. So it's resisted, it's a fishing expedition and so on. We then have another letter, 1326 of the bundle.
Yeah.
Paragraph 12 in the middle of that page.
Yeah.
So again, it's resisted on a narrower set of grounds now, the one that I addressed at some length in submissions.
Yeah.
And then again, in my learned friend's skeleton argument, does my lord have that?
Yeah. Yes.
It's at page 12. At the bottom of that page, paragraph 36.6, we have the category that we've just been discussing. And the same position is reiterated for a third time.
Yeah.
And I just...
They don't reiterate the fishing point.
No, the fishing point is gone, understandably, but we're left with the Liberty devices only point. And my lord, if my lord still has the bundle on the page we were just on, 1326.
Yeah.
So my lord's seen paragraph 12 and the opposition that's put out there, but then for good measure, over the page, at paragraph 19,
yeah,
we're told that the application will be withdrawn, otherwise my learned friend will bring this letter to your attention on the question of costs, my lord.
Yeah. Okay.
So it's just not realistic to suggest that this has always been agreed and that we ought not to have pressed for this order. Now my learned friend can address that further in costs if she really wishes to come back to the point. But I'm grateful for the change of position. I'm very grateful that we don't have to canvass the rest of the order. There is, however, again, a point I need to make about 2.10, just to make sure we are absolutely clear about the terms of the order that is agreed.
Where is it in your skeleton? I can't remember.
The best place to find it, because we propose specific terms in correspondence.
But I just want, I've taken a lot of this from your skeleton, so just give me a second.
Oh, yes. I'm sorry, my lord. Well, I can take you to that. It's at paragraph 84.
84.
83 and 84 on page 23.
Yeah,
and,
that's what I was thinking.
Indeed, my lord's guidance has been helpful, because that leads me, the reference there in my skeleton argument is to the letter where we've set it out more specifically at page 1435 of the bundle.
Yeah.
Now, just the background to this, my lord. In fact, I ought to show your lordship just this 3 short letters, because it illuminates why we end up where we are. Now, my lord will have picked up that the first time that we heard anything about this was being told in Mr. Kahlon's witness statement that he had not earned any income since May 2022. And we found that surprising, and we asked him in correspondence at 1357.
Want me to go there?
If you wouldn't mind, my lord, it just will help explain why we put the request in the way that we do.
Yeah.
And so in paragraph 2 there, we quote from Mr. Kahlon's. Yes. And then what we receive in response is at 1431.
Yeah.
And our client reiterates the statement he made in Kahlon 3, which is, of course, that he had made no income.
Yeah.
So, my lord, there's just no attempt to explain what the situation is. And indeed, this is obviously given on instructions. Now, that is why at 1435,
yeah,
we said in paragraph 2, you've declined to explain the apparent inconsistency. And so we've asked the questions much more specifically. Has he worked on any acquisitions in the mining and metals sector, as he says in his LinkedIn profile? Has he been involved in any personal coaching, as he says in his LinkedIn profile? Or indeed, has he provided any services for any benefit, including payment to a company or so on? Because he says that he hasn't received any income, and we're concerned that that is carefully worded.
Yeah.
And so we've said we're content to confine the request at paragraph 2.10, rather than to all financial records, to tax returns and bank statements, but including of any company, trust, or other legal entity he controls, because he says on his LinkedIn profile he is self-employed. It would hardly be surprising if he's conducting business through a limited company and is receiving an indirect benefit in that way. And if there is, then we would like to know about it, because it's not a question about, of course, he has the burden to show he has mitigated his loss, but equally the other side of that coin is if he has in fact mitigated his loss, then he has to give credit for it, for any damages he's awarded in trial. So there's no engagement with that in response. There's no engagement with that in my learned friend's skeleton. And my learned friend said a moment ago that they were content to agree to the order in the form we had proposed, but I want to be abundantly clear about what that form that we seek is and why.
I put it very loosely to you, Ms. Ahmed. From the skeleton, I said tax returns and bank statements. The full wording is on page 1435 in paragraph 3. And is that wording? Is there any difficulty with that wording? That's to replace 2.10.
Subject to, your lordship, of there being suitable redactions for any material that's confidential and not relevant to the issue of him earning an income that might go to the mitigation point.
I think that's implicit in everything that's been ordered. Is that right?
Well, my lord, it's of course standard for any
redactions in the first instance. If there's a dispute about what's redacted, then that can be brought before the court.
Well, quite. Although, of course, my learned friend has the benefit of the confidentiality ring, and so things can be disclosed into that ring, and things ought not to be redacted if they are relevant to the issue. And so we would expect him to take a sensible approach to that. Now, we don't need to see, for example,
we don't need to micromanage that potential dispute. Yes,
quite. Yes.
If a problem arises, I hope you can deal with it between you.
I'm sure we can, my lord.
Right. Okay. So on that basis, so I'm going to put a tick against 2.7, 2.8, 2.9, and 2.10 as modified by that letter.
Your lordship, I'm grateful, but can I just go back to the point about sort of this kind of agreement, or rather my learned friend's submission that the issue in relation to Miss Katrina was subject to the extent that they only exist on the Liberty devices. Your lordship, there was some movement on this, and if I can perhaps take you to Davidson and Co.'s letter dated the 17th of January, 1352 of the bundle.
Right.
And it's 1354.
Yeah.
And at paragraph 17, it's the issue in relation to the searches of the Yahoo account, and they recite paragraph 65 of Mr. Singh's fourth witness statement, where he indicates that KBH will review the Yahoo account subject to search words being provided for. And over the page 1355, the defendants then at point 31 of that table provide the date range, and it's the third row down.
Yes.
As well as Miss Katrina's email address. And
Yes.
to that extent, your lordship, there was agreement, because then on the 22nd of January, KBH write, and it's a letter in the supplemental bundle.
Page what?
Page 13.
Yeah, internal page 13.
Internal page 3, bundle page 13. and where they say that they will not only search in the Yahoo account at 17 and 18, 17 rather, but they will at 19 say they will also search the personal hard drive. And paragraph 22, on condition that reasonable parameters are agreed, those parameters were agreed by reference to the letter of the 17th of January, where Miss Katrina's email address was given. And then at paragraph 23, in light of the above, please confirm the following by return. The keyword state ranges of senders recipients will be provided in respect of the hard drive on the 23rd of January, because obviously Katrina's address is by reference to the Yahoo account, and the application will be withdrawn forthwith. And so to that extent, Your Lordship, there was agreement with regards to the request in relation to Miss Katrina.
Right, but there's no objection at the moment to 2.6 as it stands.
Your Lordship, the only thing we would say is that the
I
date
thought we'd
range...
reached that point. I thought we'd reached agreement on that.
We have reached agreement, Your Lordship. All I would say, though, is that the date range is quite wide. It covers 3 years. It's very broad. It's very extensive. The request is very extensive. I mean, the issue, as we understand it, is that the claimant had a romantic relationship, which is denied. But what this request is seeking to do is go beyond that and consider and require and request all and any communications between the claimant and Miss Katrina over a 3-year period, which we say is quite obviously disproportionate.
Well, we've moved on from 2.6. It seems to me that on the basis of the decision I made 20 minutes ago, half an hour ago, I'm going to grant 2.6, subject to the other points we're going to discuss. Right.
Thank you, my Lord.
Should we stop for? Are we going to move on to another category of discussion?
Yes, my Lord. I wasn't going to engage any further on that issue about whether it was agreed or not agreed, or agreed and then not agreed, or not quite sure what. But anyway, moving next on to the document production statement. So if that's a convenient time to take a break, then
let's have. We're on time to finish in an hour. If we come back at 12:30, finish by 2.
I think we should be able to do that, my Lord. Yes, I'm optimistic.
Yes, that's always worrying. Right, we'll resume at 12:30 UK time, which is it 4:30 your time?
Yes.
UAE time. Yeah. So that's just under a quarter of an hour. Thank you.
Thank you, my Lord. Thanks.
Yes. Good afternoon.
My Lord, we're about to move on to the document production statement.
Yeah.
The request on the document production statement, perhaps we should just look at the draft order to begin with.
Yeah.
My Lord will see that we're now into paragraph 3.
Yes.
Where we have asked for specific things to be done in the document production statement.
Yes.
Now, what I'd like to do is to go first to the rules and then to go to see what Mr. Kahlon has done already and explain why it is not satisfactory. So if Your Lordship has our authorities bundle, we've put in it the rules, although indeed
have the rules changed in the last year or a few years?
Well, we shall see.
Okay, what do you want to go to?
I doubt it, but if we go to 23.20.
23.20.
Sorry, 28.20.
Right, I've got it.
Now, this is the by now familiar provision, which is the requirements for document production where there's no objection.
Yeah.
And the first 2 paragraphs we don't need to concern ourselves with because they're about searching for and producing documents. It's 3 and 4 that we're looking at. So paragraph 3 provides the other parties information about his document retention policy and the nature of the searches which have been undertaken.
Yeah.
And then 4 states that to the best of his knowledge, the necessary documents have been produced.
Yeah.
We see why the information about the nature of the search is required in the next rule at 28.21. because it's necessary to carry out a reasonable search. And in order to establish whether there's reasonable search, one needs to consider various things. So one needs to consider the number of documents, nature and complexity of proceedings, ease and expense of retrieval, various subpoints, and then 4, the significance of any document. So that's what indicates whether or not it is reasonable. Now, these rules don't themselves refer to a document production order in terms, sorry, a document production statement in terms. But if one looks at 28.42,
Yeah.
now we're talking about a document production statement that comes following a document production order, such as the ones that your lordship has just made.
Is it? I haven't made it yet.
Oh,
But I've, a document production order is starts at 2836.
yes, my lord. So if we skip forward to 42.
No, the only reason for looking at that is the document production order a term of art? So where is it defined?
That is, it's defined in 28.38.
Yeah.
So the court may order a party to produce requested documents.
Yeah.
And then 28.42 has to be verified by a document production statement.
Right.
And this is the first time that that term is used, but in a sense, the parties have all been proceeding on the basis that the statement that's required when you produce your production in response to a request is in the same form as the production statement that you make once you've been ordered to give something further. And then one sees at 28.43 what the document production statement is. And again, it's very similar to what we saw before. It's setting out the extent of the search that's been made to locate documents.
Yeah.
And in a sense, none of this is surprising because it's the same territory we went over on the last occasion. It's the document that's meant to enlighten for the other party what it is that's been done in order to verify whether something more should be done. Now, there is a standard form for these, but they are quite bare bones. If one looks at, does my lord have Schedule B?
I just looked at it, yeah.
Now, of course, the nature of the search that's conducted in any particular case could vary wildly, depending on the type of case, the type of party. Are we talking about an individual, a corporation, a government, and so on? And so necessarily this template is very much an outline. But one sees, first of all, I, the claimant or defendant, state that I've carried about reasonable search. And then in square brackets, explain what was searched and the extent of the search. And those words, the extent of the search, are what we saw in the rules before.
Yeah.
And then down a bit further, there's electronic documents. This is where it really matters in a sense. I carried out a search for electronic documents created on or by the following, and again, explain what was searched. And then on the other hand, I did not search. And then one sees first 1, the date range that was excluded, and then 2 and 3, documents contained on or created by, and then various examples listed. So the claimant's PC or the claimant's database, the claimant's service, and so on. Now, clearly enough, the purpose of this is to indicate what repositories a party has available, but were not the subject of a search.
Yeah.
Because that illuminates, one illuminates the dates that were excluded, one also illuminates the repositories that were excluded.
Yeah.
Now, there's a case in the bundle about this. Perhaps we ought to look at it very quickly. It's in our authorities bundle, page 295.
Yeah. Yeah. 295.
Yes, my lord. And does my lord have paragraph 7 at the top of the page?
Yes.
And one sees just down the middle of that paragraph.
I just want to see what it is.
I'm so
What
sorry.
case it
It's a
is.
decision of
Oh, I know the case.
yes. But in a sense, I'm not too worried about the facts. The principle here is actually being quoted from Tallinn, which is the decision on which my learned friend relied earlier. And it's the part in the quote. So when no document's been located, then it's in the context of a search which has been ordered, the extent of which has been specified, that provides a context in which the court and the requesting party can see what has been done to find the documents and can take a view about whether the fact that they've not been located after a search is a reliable indication that they probably do not exist, or at least they could not be found without a search, which amounted to an unreasonable burden.
Yeah.
And just to interpolate there, the same applies where some documents have been found, but not as many as one would expect.
Yeah.
So one can look at what's been done and decide whether the other party has gone far enough in their search.
Yeah.
And if one just looks down on page 297, and again, I don't place any particular reliance on the facts of this case, but one sees the sorts of orders that can be made to ensure that that happens. And so at 1F, at the bottom of the page, we have to that end an order identifying the private email accounts in use in the particular period. And in 1H, giving an explanation about what documents have been lost. And again, I don't place any particular reliance on the facts of this case, but those are illustrations of the sorts of things the court can do, unsurprisingly, in order to make sure that everyone is in a position at trial to assess whether the absence of documents is attributable to a failure to search for them or because they don't exist.
Yeah.
In a sense, none of that is probably very controversial. It's all well-trodden ground in any jurisdiction with a disclosure regime. Now, if we look at what the claimant has done, it's at page 805 of the application bundle.
$805.
Yes.
Yeah.
So, my lord, this is the document production statement given in November. Of course, the premise is that production's been complete at that stage. But if we go down to, on the next page, 3.2.
Yeah.
In fact, if we start at 4, for electronic documents, I carried out a search of electronic documents contained on or created by the devices listed above. And then one has 5 devices or 4 devices and some hard copy files listed there.
Yeah.
Now, that turns out to be inaccurate, but I'll say more about that later. Then at 5, we have the inverse. I did not search for the following. And for present purposes, this is really where the problem lies, because he goes on to say, first of all, documents outside the date range, that's fine. Documents created on, contained on or created by the following. And my lord, this is unhelpful because it doesn't tell us anything about these documents, databases, what databases, 5.2.5 over the page, mobile phones, laptops, PDA devices. You know, what are we talking about here? Which devices? How many? But then this is really the kicker. One sees following that, as I did not have access to such devices and or locations and or such locations did not contain any relevant and disclosable documents.
Yeah, that's
So-
circular.
Yeah, like that precisely.
If
And
you didn't search because they didn't have any relevant stuff.
yes, exactly. That's the first problem. The second problem is it doesn't even allow us to ascertain which of the things in the list were searched because they didn't have any relevant stuff, and which of the things in the list were searched because they don't exist.
Yeah.
As he says, it's and or. So it's I didn't have access and or they didn't contain relevant documents. Now, putting to one side the fact that and makes absolutely no sense because one can't have an repository that doesn't exist and then talk about what it does and doesn't contain. But really the point is that this leaves us utterly unable to interrogate what the searches are that have been carried out and critically what has not been carried out. And I've taken my lord through all of the missing repositories that we've had to fish out from WhatsApp chats here and there and from iCloud accounts that he wasn't going to tell us about that we later spotted in the correspondence, in the disclosure and so on. But for this reason, we really need to impose some discipline on the next attempt. Because to be clear, the claimant has said in correspondence that he will produce a revised document production statement, but what he has not agreed to do is to provide the information that we've asked for. And so unless we get the assistance of your lordship today, then it will be more of the same when we get his document production statement in due course. Now, can I take your lordship then back to the draft order to see what we're asking for?
Yeah. Mm-hmm.
So again, a lot of this is machinery. I don't think it should be all that difficult. So first of all, 3.1, tell us what the repositories are and confirm that the lawyers have satisfied themselves as nothing else.
Well, we don't have to come back to that, but yeah.
Yes, of course, there's this, in a sense, embedded in this parts of it, the involvement of the lawyers, but parts of it are freestanding as well.
Yeah.
3.2, in respect of each of them, tell us if it's been searched or not.
Yeah.
If it's been searched, tell us what was done. So who searched it? Were they individually reviewed? Did you filter them first? If you filter them, how did you filter them? And so on. And if you didn't search it, then tell us why. Is it because the circumstances are such that it's not likely to contain relevant material?
Yeah.
Or is it because it contains some relevant material somewhere, but it's such an enormous repository of documents that it would be disproportionate and totally impossible to interrogate it?
Yeah.
That's 3.2. 3.3, in particular.
With 3.2.3, for example,
Yes.
it wouldn't be enough, or would it be enough to say it's disproportionate, or would you need to say why it's disproportionate?
Yeah, my lord is.
The example you gave, there being thousands of documents, looking just for one, you wouldn't find it.
My lord is quite right, because in a sense, if it were left at disproportionate, really it would just inevitably follow in correspondence. There'd be a question: why is it disproportionate? And the risk is that we get an answer saying we don't need to tell you, and then we're back before your lordship. So that my lord is right. They really should say and why.
Yeah.
Then at 3.3, in particular, that the following repositories have been inspected and considered. Now, we'll come to the issue of principle. We say that it should be the claimants the legal representatives who consider them. My learned friend will say, well, at most, it should be the claimant himself. We'll come back to that question. But these are the repositories that I took your lordship to earlier. the ones that we have identified that have not been searched so far. And in fact, my learned friend said that there was no opposition, at least to the Gmail account. And it wasn't quite clear whether there's opposition to the iCloud account or not. There might or might not be. But in a sense, those are the other places we've identified, and they ought to be checked by someone.
Yeah.
Now, over the page 3.4, confirm that the claimant, and we say the claimant's legal representatives, have considered where the following documents might be found. And these are the documents, the categories in respect of which, at the time of issuing our application, no documents had been produced. Now, in fairness, some documents have now been produced in respect of the ArcelorMittal issue.
Sorry, hang on a second. Can I just read 3.4?
Yes, my lord.
Yeah, so you have to talk me through 3.4. I don't quite understand what it's getting at.
So 3.4, my lord, these, and we can go back through all the evidence, but these are the issues in respect of which, at the time our application was issued, no documents had been produced.
Yeah.
And it's set out in Mr. Swangard's witness statement. In fairness, 3.4.2, little c should be deleted there because some documents have been produced in respect of that.
Yeah.
And 3.4.3 is about the financial records, that nothing had been produced in response to that. Now, in a sense, there's been some development in the course of submission. So it may be that we don't need that paragraph. But the point of it was to ensure that some consideration is being given to where these things might be found. At 3.5.
So you're saying we possibly don't need any of 3.4?
I think we can do without 3.4, given where we are.
Right.
3.5, in relation to the hard copy files, please tell us where the emails and documents were printed from, because it said that documents and emails were printed and then provided to KBH in hard copy. Some of them at least were printed from the Yahoo account, but we don't know if all of them came from there. That may be a simple answer to that. 3.5.2, there's a reference to about 15% of the hard copy files are said to have come from miscellaneous hard copy documents. We don't know where they came from.
Yeah.
And then sub 3, what other searches have been conducted? So in a sense, that's just the ordinary requirement to explain the searches.
Yeah.
And then finally, 3.6, in relation to lost or destroyed documents. First, 3.6.1, confirm when the iCloud account was removed and whether the claimant retains access. My lord, we covered that before. The iCloud account was removed from the Liberty devices at some point, and we don't know whether the documents have been destroyed as a result. And 3.6.2, confirm whether any other documents have been destroyed or lost, and if so, explain the circumstances. And that's the sort of order that we saw a moment ago in the decision of Justice Giles.
Yeah.
So that's the sort of information that we'd like to see so that we can understand what's gone on. And my learned friend will say, well, we'll file a production statement, it'll be done in accordance with the rules and so on. But there's already been one attempt. It hasn't been satisfactory. Our attempts to impose some discipline and make some specific requests have been ignored in correspondence, and there's no promise to remedy it. So we need a bit more guidance on this occasion.
Right. And we're going to do this as a separate topic from the other one.
It might be sensible to deal with this first and then move on to the question of principle.
Because
Subject to your lordship.
The question about the claimant's legal representatives throughout this one brings into play the other item of dispute.
Yes, my lord. Well, I'm happy to deal with that at the same time if it would be useful.
I think it might be useful. Then we can know where we're going.
Thank you, my lord. Yes, I'll do that. So, my lord, my lord knows what the question is. Now, there's been some movement recently in relation to this, some of it encouraging and some less so. Your lordship will have seen that quite a lot of Mr. Singh's witness statement is devoted to explaining why the rigours of the English system do not apply in the DIFC. And that point is advanced in my learned friend Skeleton as well.
Yeah,
but there has been some concessions. First, in evidence, it was said that the Yahoo address, the Yahoo account, will be handed over to KBH. And then in a letter yesterday, we were told that the personal hard drive will be handed over to KBH as well. My lord, there are a couple of difficulties with that. First of all, the offer that's been made is highly conditional, and we are concerned about rowing back, especially in the light of some of the things that have happened this morning. If we go to the supplemental bundle at page 14,
in the
supplemental bundle.
Yes, but which page 14?
Oh, I'm so sorry. It's so it's internal page 13, PDF page 14.
Okay, yeah, okay. If we can stick to the internal pages, this just makes it easier.
Thank you, my lord. I'll do that. This is the letter we received yesterday afternoon.
Yeah.
If we look at paragraph 19, we note the comment of your client's skeleton argument that there was no such offer in relation to the personal hard drive. We assume this is a reference to our letter of the 31st of December. That's wrong, because the Yahoo account was, of course, offered up in evidence, not in the letter. So that offer was made on the 15th of January. And there was no offer at that time, or indeed at any time until this letter, in relation to the personal hard drive. Then the next paragraph, we get criticised for belated engagement around Christmas. Of course, my lord will remember what was going on around Christmas. Now, we're now told at the end of 20, he's now had access to it and confirmed that he will provide it to us so we can conduct searches. So that is encouraging, although, of course, it comes nearly a month after our request.
Yeah.
Now, but this is the problem. The 21, this offer is made without prejudice to our primary position that, one, there are no red flags, and two, there is no specific duty. And so what that means is that there is no general agreement going forward that in relation to the various other repositories I've identified and the various other searches that the claimant will be required to do on those repositories, that they will be conducted out by solicitors. And then 22, the offer is also made on the condition that reasonable parameters are agreed. And my lord, that is the wrong way around. The order should be made, and then if there is a debate about proportionality of parameters and the extent of the search, that follows after. But at the moment, there is no clear and unequivocal agreement to search the hard drive. And we're concerned about a response that comes a few weeks down the track to say, well, we've considered your parameters. We don't agree that they're proportionate, and so we're not going to do it at all. So, my lord, if we look at the draft order,
yeah.
back at 1.1,
Yeah.
claimant shall provide access to the personal hard drive and the Yahoo account. 1.2, instruct his legal representatives to carry out a reasonable search in respect of the existing categories.
Yeah.
Those are the ones that were already in play before today, and produce those documents within, we can deal with timing later. In a sense, 1.1 to 1.3, as we understand it,
Hold on
are
a
either
second. 1.2 doesn't make sense. There's a little Roman 1 in brackets in the middle of it, but no other Roman number.
yes, my lord, that's an infelicity of drafting. So the colon and the little Roman 1 should be deleted.
Okay.
Right.
Right.
The reason for that is that there was originally a Roman 2 that referred
to
the new categories, but now that's in paragraph 2.
Okay.
So 1 is all about the existing categories. In a sense, that should be unopposed, given what we've heard. And then it's not really for today to work out exactly what the parameters of the reasonable search are. And I would hope that the parties can agree that without having to trouble your lordship.
Hope so.
Yes, indeed. But the trouble is that going forward, in the various categories under number 2, we don't accept that the searches should be confined or should necessarily be confined to the Yahoo account and the personal hard drive. And just by way of example, in relation to the communications with Ms. S, I took your lordship through a large number of other repositories that are available.
Yeah.
And indeed, it seems to be agreed that at least some of those could be provided to KBH. But it wasn't clear whether it seems, at least on the face of the skeletons, that there remains a dispute of principle about whether that's how disclosure should be carried out. And so in the light of that existing dispute, I need to address your lordship on the law on this point.
Yeah. Yes.
Now, I propose to do this quite briefly, not least because there's not a great deal of time. If my lord goes to our authorities bundle,
Yeah.
the leading authority which the lordship will have seen in England is Hedrick, but Lord Justice Ward is there quoting from the text on disclosure. So in a sense, we can just take it straight from there. It's page 252 of the bundle.
Which bundle? Am I in the authorities bundle or not?
Yes, our authorities bundle, the defendant's authorities bundle.
Defendants, sorry, yeah. Hold on a second. Page what?
252.
Yeah.
Now, these are the principles in England. In a sense, I can take them quite quickly because the dispute is about whether they apply in the DIFC or not, rather than what the scope of the principles are in England. And so at the top of that page, the solicitor has an overall responsibility of careful investigation. Could your lordship just read that paragraph down to the words disclosure process, about 2/3 of the way down?
Yes.
And then if one goes over the page, just looking at subparagraph 6, It's absolutely fundamental that the client must not make the selection of which documents are relevant. And then if we go over the page again, at the bottom of page 254, we see the common sense reason why this is. Because if the solicitor becomes aware
Yeah.
that the disclosure is inadequate, or that the statement of truth is inadequate and omits relevant documents, is wrong and misleading, he's under a duty to put the matter right at the earliest opportunity, should not wait for a further order of the court. And then at the very bottom, if the client's not prepared to give full disclosure, then the solicitor's duty is to withdraw. And of course, these are all very familiar and well-trodden principles. Yeah. And the reason is that the court relies on its officers to ensure that when the review is being carried out and a particular document is alighted on that may be unfavourable to the client's case, but is responsive to the court's order or disclosable under whatever regime applies, that the solicitor makes the decision to disclose the document rather than to suppress it.
Yeah.
Whereas, of course, clients come in many shapes and sizes and do not owe similar professional duties.
Yeah.
And that emerges in various of the cases. We don't need to go to all of them, but it might be useful just to see a recent statement of principle from Mr. Justice Robin Knowles in the Mozambique case at page 175. Paragraph 8. My Lord just reads that paragraph.
Yes.
That's really just the point I was making a moment ago. And then well done with a similar statement at 172. Page 172, rather.
Yeah.
At paragraph 200, this is a postscript in a trial judgment. I must underline the paragraph from the practice direction to which counsel drew attention does not and is not intended to set out the extent of a solicitor's relevant disclosure duties. I draw attention to that because this is not a requirement that comes out of some idiosyncratic part of the CPR. And His Lordship continues, it's fundamental that the client must not make the selection of which documents are relevant. Compare the allegation in this regard made on the Clayton side. And the position is well summarised in the disclosure text we've just seen. And one sees there immediately below solicitor's duty, and then the quote there, it's one on which the administration of justice very greatly depends.
What has caused me some uncertainty, I was looking at this yesterday, some uncertainty is the word supervision.
Yes, my Lord.
I'm not sure whether that is more closely defined. I was looking at the CMCS case, which I think uses, perhaps explains it a bit more. But
yes, my Lord, that case does provide some useful guidance. Should we go to that? If we can pick it up at page 98 of the bundle. So just to remind Your Lordship what this case is about, in a sense, the facts are not that important, but they help provide some context. So it's a matrimonial dispute. The family home is owned by a company, and the company applies for a possession order to kick out the wife. Yeah. The company said there's a new purchaser who's the beneficial owner of the property, Mr. Jacoba. Mr. Jacoba turns out to be a Swiss man who I think is a sort of asset manager. And there's an issue about whether the company was really just owned by Mr. Jacoba. And some redactions are applied to a set of documents. And Mr. Jacoba and the company refuse to lift those redactions, and as a result are debarred from defending. The wife was successful at the uncontested trial and then applied for a wasted costs order against the solicitors. So we're in a quite different procedural context.
Yeah.
But that's the background. So when we're talking about supervision, we see at page 98, first of all, paragraph 21. In the middle of that paragraph, secondly, Mr. Jacobo had informed Halliwells that his redactions had been carried out so as to avoid a breach of confidentiality under Swiss law. Thirdly, Halliwells had obtained from Mr. Jacobo Swiss legal advice.
Yeah.
So Mr. Jacobo has been advised about the scope of his duties, and one sees that further in 22. The evidence does not show whether the solicitors knew that Mr. Jacobo redacted the statement. And further down, it is, however, clear and not in dispute that Halliwells did not supervise Mr. Jacobo's redaction of the BCP bank statement, nor a fortiori carried out themselves. So it's tolerably clear that what the court's saying here when they're talking about supervision is supervision in a sense of seeing that it is done rather than giving advice about what one should do.
But not necessarily hands-on looking through every document. Otherwise, that's carrying out the process itself.
Yes, my lord.
So if you look at paragraph 40.
40, yes.
Where are we? Yeah. Just about 8 lines down, reliant upon the solicitor's duty to carry out or at least personally to supervise.
Yes.
There seems to be a distinction between carrying out and supervising.
Yeah, yes, my lord.
I'm not quite sure what that distinction is. And the obvious distinction is that when you're supervising, you're identifying with the client what you think are the relevant documents or the relevant files to look at, and say, can you look through those and bring out anything that relates to X, Y, or Z?
Well, my lord,
is that too hands off?
I suggest that is too hands off, because here when we're talking about redactions, the distinction I suggest is this. Doing it oneself is the solicitor physically getting the document and applying the redactions themselves.
Yeah.
Effective supervision would require the solicitor to have seen the document, redacted and unredacted, and to understand precisely what is being done and what is being repressed. Because the examples, for instance, Myers and Ellman that's being cited there is the case about the checkbook. And so the part of the checkbook is sealed up. Now, the solicitors in Myers and Ellman knew full well that the client had sealed the checkbook, but that wasn't sufficient because the solicitors hadn't inquired about what was in the sealed portion of it, or at least should have done. And so
if they had inquired and been told something, would they then be obliged to look at it?
Well, yes, my lord. The critical point here is that the solicitors need to actually know what has happened, rather than just rely on the client's assertion that a particular document is relevant or not relevant. And I mean, one sees that, for example, in Lord Porter in Myers. We can see that at page 58 of the bundle. One looks at just the last large paragraph in his lordship's judgment. I did not consider that the solicitor or his clerk have fulfilled the obligation of supervising to the best of his ability.
Page 58.
Yes, my lord.
Oh, I see. I found it. Okay.
Yes. I do not consider that the solicitor or his clerk has fulfilled the obligation of supervising to the best of his ability the swearing of a full and complete affidavit of documents, which is, of course, the method of doing it in those days, by permitting the client to disclose the passbook and withhold the rest, using for that purpose the phrase relevant entries only. Until it is known to him what those relevant entries are, disclosure is not complete. And so what his lordship's there saying is that it's not enough to just take your client's word for the fact that a document is relevant or not relevant. Yeah. The solicitor has to either do it, which is the normal way, or to supervise it in such a way that he knows what's going on. And the distinction between those two things, my lord, really is one of proportionality, because of course the gold standard is to do it yourself, and that's the way that these things are usually done. And there's not really a serious proportionality argument in this case, because the claimant's disclosure is, on any view, very much more confined than that of the defendants. I mean, his responsive disclosure was 114 documents, and this is the claim where he claims at least $32 million, and on the basis of his treble damages claim could be north of 100 million. So we're not talking about, but we're just not in the region of any sort of disproportionality argument, especially when we're talking about electronic repositories that can very easily be either handed over by giving access with a password, or they can be imaged. A hard drive or a computer can be provided for a day, an image can be taken, and then that image can be reviewed. And my lord, that is listed as bread and butter. It's standard practice, easily done.
So if one was to think in terms of the word supervision, that covers, that effectively means being hands-on and going through the documents, checking them for yourself, by the solicitor.
Well, yeah, my lord, yes. I think that is what it requires in the context of this case, because there's no other, there's no sensible intermediate ground, because
so I'm just trying to think how it would fit within your category 2, for example, paragraph 2. Within 14 days of the date that's all the claimant shall, you say, by his legal representative. If you were to say under the supervision of his legal representative, that would be more in tune with the language used in the cases, but without any difference of substance.
Well, my lord, the concern about that is it introduces an ambiguity about what's required.
But it doesn't, because I was going to suggest that there then be an explanation by the solicitor of what their supervision involved.
Well, the difficulty is, my lord, we've had explanations in evidence on this application, and it's been somewhat of a jigsaw that we've had to unpick. They've been extremely unclear, and it is now clear, beyond any doubt, that the claimant has been involved in reviewing and selecting individual documents for production, because we were told that in correspondence yesterday. But what we are asking for in the order is that it should be in accordance with the statements of principle that we've seen in the cases, the solicitors who make decisions about whether the documents are relevant or not the client. And again, there could be a proportionality objection to that in an appropriate case. And my learned friend, in fact, refers to one such case, which is the IBM United Kingdom decision.
Yeah.
But my lord, in that case, the evidence was that $15 million had already been spent on the disclosure exercise. And so some of it was being delegated to people at the client, which was a corporate entity. And of course, there is a proportionality question in every case, but in this case, where we're talking about an individual who has on his own evidence a limited number of repositories and a limited number of documents, and is claiming for a substantial sum, then there is no proportionality reason why his solicitors should not be getting access to his electronic documents and conducting the review. Now, there's a separate proportionality question about how that review takes place. Are the documents reviewed individually? Are they filtered by keywords or date ranges, by senders or recipients? And the answer to that question may be different depending on what the repository is, what the documents are. And that's all in the ordinary course.
We are saying the decisions about that should be made by the solicitors rather than left to the client.
Yes, precisely. Because it's only once one opens if you're a solicitor and you receive a hard drive full of documents, you open it and you see how many folders are there, how are they organized, are the documents searchable, Are they filterable by date range? And then you make decisions about what a proportionate search is. Now, the claimant has invited our input on that, and we welcome that. But in a sense, none of that is for your lordship today. The question is, should it be the solicitors who make the decisions about whether documents are responsive or not? And we say the answer is obviously yes, because some of the requests that have been made previously and which your lordship has granted today are of a nature where it will be important for the solicitors who have duties to this court to be making the decisions about whether to disclose the documents or not. But in a sense, it's a question of general principle, and it should be the solicitors who make that decision. Now, my lord, it's been suggested that this principle does not apply in the DIFC, that there is a different system.
Yeah, I've seen that.
Now, I'm going to say this very briefly.
Should I hear Ms. Ahmed on that first?
I'll say 2 sentences about it and then hand over to Ms. Ahmed.
Right.
But as your lordship will have seen from the skeleton, to our mind, it confuses 2 things. But first of all, one has the scope of the disclosure obligation, and that takes all shapes and sizes. So in the old days, Peruvian guano train of inquiry, then one had proportionate and reasonable under the CPR, and now one has model-based disclosure in the practice direction 57 AD. And in the DIFC, one has request-based disclosure, which is not all that different. But in a sense, that doesn't matter. The question we're concerned with is whatever the obligation is, who is it that should be selecting the documents and deciding whether they respond to that obligation or not? And the same rigor applies in this jurisdiction as it does anywhere else in the common law world.
Yep. Sorry, I've cut you short, but that basically covers the points you wanted to make on both section 1 of your application and section, section 1, the beginning of section 2, the first 2 lines of section 2.
Yes, and it also covers the references to the claimant's legal representatives in
various
in various other parts. That's right. And now my learned friend has another point where she says there's no red flags, and my answer to that is it doesn't matter. But if there are, then I'm happy to take your lordship to a great deal of number of red flags, and I've canvassed some of them already, but it may not be necessary. I'll be guided by your lordship. Yeah.
Okay. Well, I'll hear Ms. Ahmed.
Your lordship, it might be useful to start off with the points that we do agree with. So it's agreed, of course it is, that there, and it's generally correct as a broad principle, that the production process depends on solicitors.
Yeah.
But what's not agreed is the absolute application. And we've heard from Mr. Trotter today that absolute application is that in all circumstances and in all situations, supervision, as far as he is concerned, means the solicitors getting involved, carrying out the disclosure, looking under floorboards, behind shelves, and doing the disclosure process themselves. And we say, pardon?
He wasn't going that far.
Maybe
example,
he wasn't.
He said you could look into the filing cabinet and see certain way things are stored and so on, and that might enable the solicitor to say there's nothing there relevant and so on.
Well, my lordship, we say that sort of overstretch is an overstretch, and we say it's misplaced in the context of this case, because that application that my learned friend postulates depends on the specific facts and the context of a case. And the other point of agreement is that both the RDC and CPR require supervision. But we say, and that's the point, and your lordship expressed the point probably a lot more eloquently, that what is the extent of this supervision? And what we say is that it doesn't require a solicitor, let's say overseeing disclosure, to be physically present and actively is going through various repositories and so forth and carrying out the disclosure exercise. So that's active supervision in our submission. Neither regime, be it the RDC or the CPR, suggests that that sort of active supervision must be carried out by the solicitor in the way that my learned friend is suggesting. And what we say is that it is obvious from the authorities, and my learned friend touched upon it, that if there are red flag instances, now what I say about what these red flag instances are, such that they might be concealment, or that there is something tantamount to fraud, and then one can argue that my learned friend is correct and his approach of investigation and active supervision as described might be correct. But we say,
sorry, can I just ask you, where do you get this? Is there any authority that points to
Your Lordship, I'll take you. Yes,
support
and
you
I'll
about
take
the red flag?
Well, the red flag is sort of my term, but what I say is that the authorities say that if there is something that gives rise to a point of investigation, so for instance, in the Myers case, it was that the client had given the solicitor information, which the solicitor knew to be imperfect, then in those circumstances, the solicitor must do more and must actively supervise or actively carry out a disclosure. And I say that that is the same for the other authorities, which I will take you through. And so we say that in terms of what the solicitor's duties are, the solicitor's duties are to supervise, to ensure that there is compliance with an order, and to ensure that the searches are reasonable and it is proportionate. There is no duty on the solicitor to carry out the disclosure exercise. And we say that that's also envisaged by the RDC, because if one looks at the RDC and Schedule B, the terminology there is that I, the above named claimant, parentheses or defendant, state that I have carried out a reasonable search to locate all the documents. So that search, the exercise of searching, is a burden or an obligation on the claimant itself, and that simply the solicitor has to supervise, and that supervision is to ensure that there has been compliance and there has been a reasonable search. And we say that that is the duty on a solicitor unless there is something untoward that gives rise to some sort of suspicion that the solicitor should go further. And just in terms of, before I take you to the authorities to make good this point, I just want to raise this point simply about what we say about the distinction between the CPR and the RDC. What we simply say, and your Lordship, you also have provided dicta on this in the case of, in your case, SBM, and I can take you to that. But
I didn't say anything relevant to this point.
No, but the simple point is that it's a very simple point. There is a distinction between the CPR regime and the DIFC regime. And so when authorities relevant to the CPR are considered, they ought to be considered in a very narrow sense in accordance with the RDC regime. And that's the simple point that I make. I don't take it any further.
Right.
Then in terms of what I say about the solicitor's duties and what I say about whether or not there is any need for a solicitor to investigate further, so this distinction between supervision and carrying on of the disclosure exercise, can I first take you to the IBM authority, which is in the claimant's application bundle.
Yeah, I've got it. Page.
Yes, page 20 of the PDF.
Yeah, I've got Mr. Justice O'Farrell. Mrs. Justice O'Farrell. Yeah. Yep.
Yes, your Lordship. Yes, Mrs. Justice O'Farrell. And the relevant part is paragraph 49. And your Lordship, this was the context of the case was that a solicitor from Quinn Emanuel had provided a disclosure statement or a certificate under the CPR rules. And your Lordship, paragraph 49, and I don't think we need to go into the facts, and and I don't disagree that this case was complex and the quantum was significant. However, it doesn't depart from the proposition that's set out there, which is at paragraph 49. And this is in the context of the solicitor from Quinn Emanuel giving a certificate. And it's at paragraph 44, Mr. Pantlin signed a certificate stating, I'm the partner at Quinn Emanuel. I'm responsible for overseeing the claimant's disclosure of documents. And so If we then turn to paragraph 49, which then refers to the oversight, Mrs. Justice O'Farrell says that this is not a proper basis because the argument there was that something more should have been done. And the judgment is this is not a proper basis on which to seek to go behind the disclosure certificate signed by a solicitor with conduct of the case. The CPR does not require a solicitor overseeing disclosure, particularly on the scale of these proceedings, and we note particularly, so that's a general proposition we say is relevant even to this case, to be physically present and actively supervise each stage of the disclosure in the absence of any identified gaps or errors in the disclosure. It is purely speculative and without merit. And we say this goes to the proposition, therefore, that there is no reason for a solicitor to carry out a disclosure. Supervision and oversight is sufficient unless there are gaps or errors. And this is what I say goes towards the point that unless there is, let's say, something of concealment or imperfection that's tantamount to, we say, fraud. And your lordship, paragraph, I beg your pardon, if I can also then take you to paragraph 52 of this judgment. And in this case, the defendants raised speculative concerns about gaps of errors in the claimant's disclosure process without providing concrete evidence of deficiencies. And we say that's similar here, where the defendants say that there are gaps. And at paragraph 52, the court dismissed the allegation and the challenges in terms of the deficiency on the basis that there was a failure to identify any specific gaps in the disclosure or errors in the disclosure exercise. The application is purely speculative. Now, your lordship, I've heard what my learned friend has to say, and he says that there are deficiencies and gaps. Notwithstanding that, we say it doesn't depart from the general proposition of what the solicitor ought to do by way of his supervisory capacity in terms of overseeing the disclosure exercise. If your lordship, we then go to the defendant's authorities, and we say none of the authorities produced by the defendant diverge from this proposition. And I'm going to invite you to turn up Myers first.
Yeah.
And I'm just going to find the bundle on my system. Your lordship, page 2 of the of Myers is the head note. And I don't need to go into the authority because we see at the second paragraph, an order for discovery requires a client to give information in writing on all of all documents which or have been in his possession or power, whether he's bound to produce them or not. But as a client cannot be expected to realise the whole scope of that obligation without the aid and advice of his solicitor, the latter has a peculiar duty as an officer of the court carefully to investigate the position and so far as possible to see that the order is complied with. And we say in this instance, KBH did do that. They aided and advised the client and ensured that the order was complied with. I'm then going to, you've been taken to the next sentence. The solicitor cannot simply allow the client to make whatever affidavit with documents he thinks fit, nor can he escape the responsibility of careful investigation or supervision. But we say that that supervision and careful investigation is qualified, and we say that the next part of this paragraph provides the qualification. If the client will not give him the information which he is entitled to require, or if the client insists on swearing an affidavit which the solicitor knows to be imperfect, the duty is to withdraw from the case. A solicitor who has innocently put upon the file an affidavit by his client which is subsequently discovered to be false owes a duty to the court to put the matter right at the earliest moment if he continues to act as a solicitor on the record. Now, I appreciate that sort of gives calls as to when a solicitor ought to withdraw, but notwithstanding that, we say, and in my submission, there is a qualification here where there is, or the solicitor knows for there to be any imperfect swearing of an affidavit or a witness statement, or that there is something that gives rise to an indication that the claimant has done something that you ought not to have done. In those circumstances, we say that the solicitor has this higher duty of carrying out the disclosure exercise himself. And your lordship, again, I think this is repeated in Headrich, page 59. And Your Lordship, in the head note, it sets out the facts, and starting with what actually happened in the case that gave rise to this application for wasted costs, which of course is a different context. But in terms of what went wrong with the disclosure exercise, we see the paragraph starting in February 2005, whilst preparing H's case, said the solicitor was told by H, the client, that certain categories of potentially relevant documents had been lost. There's been no such admission in the case, in this case. We then move to what happened next. In October 2005, Z visited H in Germany, where he was told about the existence of a CD-ROM containing files copied from H's computer by 1K, a person connected with H. After it resumes, the trial began for 7 days. After it resumes, Z provided SBL the CD-ROM containing the contents of H's computer, which Z had obtained from K a few days earlier. On investigation, this proved to contain numerous documents showing that H had provided services to a competitor. Z immediately came off the record. Now, we say, Your Lordship, that none of these facts that are set out here have happened in this case, and therefore that's something that we say would be a red flag but isn't present in this case before you. Page 65 of this PDF.
Mm-hmm.
Sorry, my computer's slow. Your Lordship, this is the excerpt from the textbook. I'm so sorry, Your Lordship, my computer's going a bit crazy and the scrolling isn't working.
Yeah, I've read it. I read it yesterday.
And Your Lordship, what we say is that, and there's no departure from this, that what this establishes is that solicitors, Your Lordship, there's an echo here. I'm not sure why.
It's disappeared now.
Yes, that solicitors must take reasonable steps to ensure their clients' compliance with disclosure obligations, including investigating potential gaps if there are reasonable grounds to suspect that additional documents exist. And we say that the reasonable steps have been undertaken by KBH. And Your Lordship, what this passage doesn't do is go beyond, or rather it confirms that solicitors are not required to go beyond reasonable steps to verify the client's disclosure. And there is nothing to say that they should go behind, unless they've got reasonable suspicion to do so. There's nothing to say that they should go behind what they're being told by their client, especially if the client has provided a witness statement with a statement of truth. And Your Lordship, my learned friend has pointed to the original document production statement, and I'll turn and address you on that when we come to that part of my learned friend's submissions. But again, where we see, and just the aspect of this excerpt, and again, Your Lordship, I'm so sorry because my scrolling for some reason isn't working.
It's 1407, the bit you want.
Yes, my apologies. I decided to be quite modern and note submissions on this PDF, but I think that's created some sort of delay with when I scroll on the screen.
In 1407, it says the best way for a solicitor to fulfill his own duty and ensure his client's duty is fulfilled is to take possession of the original documents as early as possible. The client should not be allowed to decide relevance or even potential relevance for himself.
Yes,
So
my
either
Lordship.
the client send all the documents to the solicitor, or the solicitor visits the clients to review the files and take the documents into his possession. Yeah,
Yes.
carry on.
Yes, my lordship, I'm grateful for that. And the point here is the first simple point that I was making, is that this aspect of the excerpt must be looked through the prism of what is relevant in the RDC, because there is a distinction between, let's say, standard production and standard disclosure in the CPR and the RDC, and therefore where headridge arises under the CPR, which requires for broad disclosure, including adverse documents to be provided at the standard production stage, that is not what's provided for in the RDC, because in the RDC, the standard...
I note the difference, and I'm aware of the difference, but that's a difference as to what has to be disclosed. What we're talking about is a different point, as Mr. Trotter makes clear. We're talking about the solicitor's duty in making sure that what ought to be disclosed is disclosed, and the fact that the content of the obligation to disclose differs from the CPR and the RDC is nothing to do with that point.
Well, Your Lordship, I say it is in some sense, because what they are talking about there in headridge is where the solicitor takes all of the documents and then discloses them, irrespective of whether or not there's any adverse document within there. I think, Your Lordship, there is that distinction drawn between the RDC, where the RDC in the first instance in standard production doesn't require disclosure of what is relevant, or rather disclosure of what might be adverse, and therefore in that context there's no reason for the solicitor to take all of those documents. The claimant himself can decide.
I can follow that as regards the first point, first stage, where, as I understand it, the obligation is on a party to disclose documents favourable to himself, and also those required by statute or otherwise. But we're talking about the next stage.
Yes, Your Lordship, and in the next...
Which makes it much closer to the CPR position.
Yes, Your Lordship, but in the next stage, the point again is that the solicitor ought to decide relevance. And the solicitor did in this instance. My learned friend made a submission that the solicitors make a decision as to what is relevant. And that's exactly what happened in this case, Your Lordship. Mr. D.K. Singh has given a witness statement. I can take you to it. For your references at page 532. And what Mr. Singh says is that the solicitors gave key search terms. However, in fact, what Mr. Kahlon did, he looked at each and every document. Essentially, he eyeballed each document. He provided those documents to KBH, and then KBH produced by making a decision as to relevance. And so where my learned friend says
sorry, just so I understand it, KBH made a decision on relevance of the documents that he produced to them.
He gave to them, yes.
Yes, so they didn't examine the whole files for relevance. They only examined the documents that he picked out of the files.
Yes.
What sort of supervision is that?
Well, Your Lordship, supervision, I go back to the point that I made. Supervision is aiding, assisting, ensuring compliance with the order, ensuring that...
Okay, the example you gave you, how does that ensure compliance with the order if the solicitors simply check the disclosability of the documents that the client gives them?
Well, this is exactly the point of supervision, Your Lordship. We say that...
That worries me, Miss Ahmed, that your client, if that's on instructions from your client, that gives me great concern, and would almost itself justify me making an order in the terms asked for. Well, because it's simply to look at the documents the client produces to see whether those documents are disclosable seems to miss the point entirely. Because you're not questioning or even supervising the client's initial decision as to what's relevant.
Well, Your Lordship, the KBH has supervised. They've offered search terms to the claimant. They've given him search terms.
They have now, but not at the earlier stage.
No, the earlier stage they did. It's in Mr. Singh's witness statement. But Your Lordship, before I go to Mr. Singh, I just want to deal with headridge again, because then I'll if I go backwards and forwards, I may lose the reference to Headrich. But just dealing with Headrich, a solicitor, and this is the point, a solicitor must not necessarily be satisfied by the statement of his client that he has no documents or no more documents than he chooses to disclose. If he has reasonable grounds for suspecting that there are others, then he must investigate the matter further. But he need not go beyond taking reasonable steps to ascertain the truth. And so, Your Lordship, the point is that in this case, the solicitors didn't have reasonable grounds for suspecting that there were other documents. They were provided with a document production statement. It was verified with a statement of truth. They were then given a witness statement in response to this application, again with a statement of truth. And KBH had no reason to go behind what they were being told.
Ms. Ahmed, sorry, I'm only cutting you short because I understand certain of those points. And I've already said that the first stage of disclosure, which is different from the CPR, there may well be an argument for saying, I'm not going to rule on it because it doesn't arise, but there may well be an argument for saying that a solicitor's role can be more limited because all the client has to do effectively is give documents which he thinks support his case. And so, but without deciding that, let's put that to one side. The second stage, though, is we've reached now, where certain documents are being called for on the basis that there are, let's put it this way, uncertainties as to whether there has been full disclosure of certain categories. And that is the thing that calls for the solicitors to take an active role in what you call active supervision. Mr. Trotter would say carrying out the exercise themselves. It doesn't, for present purposes, it doesn't really matter which expression one uses. But we've got into that territory now. So to say that the solicitor's role is more limited at the earlier stage doesn't help me.
Your Lordship, I'm going to take you to the second stage. I was trying to find a reference in jumping around between bundles. It's at 538.
Of what?
Of the application bundle. This is Mr. D.K. Singh's witness statement from KBH.
Yeah.
Paragraph 30. Any suggestion that KBH has not properly supervised the claimant's document production is refuted. And then it goes on to deal with Mr. Swangard's second witness statement.
Yeah.
Defendant asserts that the claimant has been allowed to conduct his own document production exercise, including selection of repositories and review and selection of documents for production without supervision of his solicitors. This is not correct. And then refers to paragraph 42 of Swangard 2. Claimant largely conducted his document production exercise personally without any supervision is both inaccurate and misleading. As is usual in this jurisdiction, the claimant as a party in these proceedings played an active role in the document production process, but at all times, as is usual, the claimant conducted himself under the clear and consistent supervision of KBH. And then it goes on to paragraph 33, KBH, the claimant's approach complied fully with the targeted requirements of the IFC production regime, which focuses on reasonableness and proportionality. KBH had oversight of the exercise, which ensured without waiving privilege, he was made fully aware of his obligations regarding production of documents. The concerns raised by the defendants are overstated. Specifically, 34.1, KBH provided detailed and clear instructions regarding the relevant repositories, the scope of searches and the categories of documents required under the RDC. The claimant's role was limited to searching for documents in accordance with KBH's instructions by applying keywords provided by KBH. This method is entirely consistent with the DIFC's targeted and proportionate document production framework. And we can see that within the RDC when it talks about electronic disclosure and parameters and key search terms. 34.3, to the extent that the claimant personally reviewed his documents, this was a necessary reflection of the IFC regime, which emphasizes practicality and efficiency over exhaustive searches, as required by the CPR. The DIFC regime is designed to accommodate the international nature, so forth. KBH maintained consistent oversight throughout the process in compliance with its obligations under the RDC. The claimant's documents span multiple jurisdictions. If the defendants are suggesting that KBH should have physically scrutinized all these locations to locate and view documents directly, such an approach would have been entirely disproportionate and excessively costly, far exceeding what is required or what could be considered as being reasonable or proportionate under the DIFC regime. And then 35, specifically, The targeted review undertaken by the claimant was based on KBH's instructions, which identified specific production requests to be addressed. Documents were reviewed by KBH for relevance and materiality before being produced. Similarly, with respect to the WhatsApp chats, the claimant personally reviewed the chats for relevance and confidentiality is incorrect. The claimant provided KBH with the WhatsApp chats in its possession, custody and control, which were reviewed by KBH. The delay in production arose from this review process. Ultimately, all the WhatsApp chats were disclosed in full and without redactions. Without waiving privilege, KBH engaged in discussions with the claimant to identify possible repositories that might contain relevant documents. KBH also provided the claimant with specific instructions regarding the parameters of the searches to be conducted. Throughout this process, KBH maintained regular contact with the claimant to oversee the extent of the searches and to ensure he understood the scope and seriousness of his disclosure obligations under the RDC. The process described in the letter reflects full compliance with the RDC. And then defendant's suggestion that the claimant selected documents solely because they were favourable to him ignores the critical role of KBH in overseeing the process. KBH provided key search terms and ensured adherence to production obligations through the DPS, demonstrating that the process was both supervised and compliant. Claimant acknowledges that his DPS contained an inaccuracy in the identification of repositories, but that is because the DPS and the claimant focused on the original repositories from which the documents were sourced. The personal hard drive was not mentioned as the claimant was labouring under a misunderstanding that only the original repositories from where the documents were sourced had to be identified and not the personal hard drive that was used to consolidate these documents. And then it goes on as follows, Your Lordship. And so we say in the context of the authorities that there was supervision, there was compliance and there was oversight. And Your Lordship, in that context, you've already referred to CMCS. May I invite you to turn up CMCS again, and in particular, paragraph 38, and I just need to find the bundle again.
Is this claimant's authorities or?
The defendant's authorities.
CMCS.
And it's paragraph 38.
Page.
And again, this goes back to the point that I was making, the red flag point. There are powerful similarities between the underlying facts in Myers and Ellman and the present case. Both cases involve the partial covering up of the client without the solicitor's supervision of relevant parts of a document. Both cases involved allegations tantamount to fraud in the sense that in the present case, Ms. Taylor maintained from the outset that Mr. Jacobo was knowingly party to a dishonest concealment by a former husband of his beneficial ownership of Wicklands Farm. And so, Your Lordship, the point is this, that the CMC case, drawing similarities with the Myers case, involved allegations of fraudulent concealment where the client had actively covered up relevant information. The solicitor failed to, in that instance, investigate further. And so when further investigation is necessary is when we say there is a red flag such as concealment or something, any allegation tantamount to fraud. And that is where we say that the solicitors overall, or rather Mr. Trotter's duty, the broad duty of carrying out a disclosure or further investigation has to be tied to some sort of dishonest conduct, let's say, by the client. In this case, there is no allegation of intentional concealment. There's no allegation of fraud in relation to the documents. The criticisms relate to procedural questions about the scope and adequacy of searches, not to, we say, any allegations of dishonesty or bad faith. And so 2 points to be made there. We say that, number one, KBH has supervised in compliance with the RDC and what's expected of it. There is no higher duty or broader duty in the way that's been described by my learned friend in terms of carrying out in the RDC. In the context of this case, if there were any allegations of concealment or fraud, then potentially Mr. Trotter may have an argument, but there is no such allegation here. And therefore, Your Lordship, we say that there has been adequate supervision as a point of principle. And my learned friend has referred you to the Mozambique case, We say that the Mozambique case isn't even relevant because in that case, the court was deciding a completely different issue, and that was whether or not particular individuals, namely legal representatives, may be lawfully authorised or designated to review classified documents. And so we say that the Mozambique case really isn't relevant to the issue, which is the extent of supervision, whether it is oversight in the way that we argue, or whether it necessarily goes further in that the solicitor has to go in and carry out and conduct searches. And we say that is not envisaged by the RDC. And that's clear from the way that the Schedule B document production statement is set out. And just in terms of then dealing with the DPS whilst we're here, Your Lordship, my learned friend has referred to the DPS and potentially may say that, well, look, that's a red flag issue. And we say, well, that's not correct. In terms of the DPS, it's at page 806. And my Lordship, I'm not even going to justify what went wrong with the DPS. Something did clearly go wrong. And Mr. Kahlon has accepted that something went wrong, and he accepted immediately that something went wrong. And so, Your Lordship, in that context, 1294, and Your Lordship, I'm also wandering into now, just for your reference, submissions about the part of the order that's dealing with the updated document production statement, if I may.
Yeah.
Your Lordship, page 1294
of
the application bundle.
Yeah. Okay. Yeah.
You've seen this letter, and it was the letter sent on the 31st of December, where at paragraph 10, Your Lordship, Mr. Kahlon says, following the conclusion of matters raised by Part B of your 20th of December letter, our client will file and serve a revised document production statement. So that's the first time he indicates that he is willing to provide and accepts implicitly that there's something that's gone wrong with the DPS. He repeats that offer on the 3rd of January. That's page 13.
What are we looking at this for?
So, Your Lordship, I'm now, well, first of all, Your Lordship, I'm saying that yes, we accept that something went wrong with the DPS, the document production statement, but that's no reason then to impose this higher duty on the solicitors to say that they should carry out and conduct the disclosure exercise.
But Ms. Ahmed, this presupposes that it is a higher duty. It is. I would suggest the normal duty.
Well, Your Lordship, when I say higher duty, what I'm saying is that the solicitors conduct and carry out the disclosure exercise in the way that my learned friend is suggesting.
Yes, active supervision or carrying out themselves.
Yes.
That seems to me that's the norm in the CPR, and that's the norm in DPS. Sorry.
Well, Your Lordship, I'm saying that that's not the norm. That's
I've heard your submissions on that. I'm now basically giving you my reaction to them, and I'm against you.
Well, Your Lordship, you're entitled to make your decision on that. You've heard my submissions on it.
Yeah.
Just to be absolutely clear, Your Lordship, what I am saying is that both in the CPR and the RDC, the duty is to supervise, and that is to ensure that there's compliance with the rules and that there's a reasonable search that's being conducted by the claimant. It is for the claimant to review his documents with assistance and aid by the solicitors, and only if there is something to give rise to some concern to the solicitor. For instance, if there is any suggestion that there might have been concealment, or if there's any suggestion of any wrongdoing tantamount to fraud, then of course the solicitor should investigate and get involved and carry out a further search to satisfy him or herself the duty of the reasonable search has been complied with.
But I think the categories we've looked at earlier today, many of them give rise to a concern that there hasn't been full disclosure so far. And it seems to me for that reason, even if a special reason is required, that is reason enough to insist that there be the active supervision. So, unless there's anything you want to tell me on the details of the order, that would be my approach to it. And I'm in principle minded to grant the order in the form sought.
Well, Your Lordship, I was going to address you on the document production statement side of it, because yes, Your Lordship, in terms of what we say that about the document production statement is that Mr. Kahlon has said all along that he will provide a document production statement, an updated document production statement.
But it's not going to, Miss Ahmed, the very fact that it's not going to be in compliance with the other part of the order, which requires active supervision by solicitors, means that it's worthless. It's not a proper document production statement in accordance with the obligations of the solicitors.
But Your Lordship, Mr. Kahlon's accepted that. He accepted that as early as 31st of December, and that's the point I'm making.
But you're still not accepting it. So how
can that's not what I'm saying. That's not what I'm saying at all.
It is actually, because you've been saying there is no need for the solicitors. You needn't shake your head so rudely. There's no need for the solicitors, you say, to be involved in active supervision. And if that's the case, then a document production statement prepared on the basis that the solicitors have not had that role in the document in the production of documents is worthless.
My Lordship, well, firstly, I apologise if you saw my shaking of the head as being rude. I apologise for that. Secondly,
we all do it. We all do it sometimes.
Secondly, Your Lordship, I'm saying that if there is reason to suspect that the claimant has done something that's tantamount to, let's say, concealment or something tantamount to fraud, then in those circumstances, there is a duty on the solicitor to undertake active supervision.
Yeah.
However, I'm saying in this instance, there was no reason for the solicitors to...
I've understood that, yeah.
What I also say
is... That's the point I've told you I'm against you on.
I'm grateful for that. Then I'm saying in terms of the document production statement. So the order in the draft order requires the claimant to provide an updated document production statement. And the point that I'm making there is the claimant has never objected to providing a document statement, an updated document production statement. He's never objected to it. He's offered an updated document production statement on the 31st of December. He offered it on the 3rd of January. He offered it again on the 15th of January when he gave his witness statement. And more recently, he offered it on the 16th of January to say that I will give you an updated production statement once I've carried out all the searches. And Your Lordship, it's noted that the defendants themselves haven't provided an updated document. Well, they haven't provided any document production statement. And so the point that I'm trying to make, and maybe I'm not making it properly or inelegantly, is that he has never objected to provide a document production statement. And so it doesn't necessarily need to be enshrined in an order. He will provide a document production statement in accordance with the rules that my learned friend has taken you to, 28.36 and 28.42. And in any event, Your Lordship, and it goes back to this point about the sort of why this application was unwarranted and why it was unnecessary, is because all along the claimant has tried to cooperate with the claimants. All along, Your Lordship, and that's really the point that I'm trying to make, that all of this could have been resolved, all of this could be sorted out. The claimant was actively cooperating, even to the point, Your Lordship, and I started off by saying this, even to the point that he has said that he is happy for his solicitors to review the Yahoo account, to review the hard drive. There's then a question of the other repositories. I have said that I can't see any reason why the claimant would object to his solicitors reviewing those repositories subject to the iCloud account. and that's because it's not known whether or not it still exists. And so, Your Lordship, in a nutshell, what I'm saying is that where there is an order, paragraph 3 in the draft order requiring a document production statement, as with everything else, there's never been any objection to it. And in fact, the claimant offered it as early as the 31st of December.
Right. Okay. So there's no part of that you object to, paragraph 3, in terms of the content of it.
Your Lordship, if it's
No,
enshrined,
you say it's unnecessary, but if I was to think it necessary, is there anything in it that you object to? 3.4 comes out, but apart from that, is there anything else in it?
the only thing, Your Lordship, that we would insist on, and you have provided an indication on this point, and I'm just going to run it again to see if we can get a landing on Mr. Trotter, is whether or not, and rather put it differently, it's our position that it would be disproportionate to do a complete eyeball search of every item on any of these repositories. And the reason being is because it will be a hugely time-consuming exercise. It would be a hugely costly exercise. Even the RDC envisages that electronic searches are done by keywords, and I can take you to the relevant provision of the RDC that provides for that. And so, Your Lordship, we would insist that Mr. Trotter and his team provide us with suitable parameters with electronic key search words so that the claimant isn't put at great expense, requiring his solicitors to go through each and every document in any of these repositories, especially given the extent of work that's required from now until trial. We've got expert reports around the corner. There are witness statements to be filed and served as well, and it would be a humongous task to expect the claimant solicitors to do that. Your Lordship, may I just put the mic on mute? I'm just being asked something. Your Lordship, it has been pointed out that there is some difficulty in the way in which this order has been phrased. Essentially, it's the claimant who has to provide a document production statement confirming what his solicitors are doing, which doesn't really sit comfortably with what it would require is not only for the claimant to give a witness statement, but for his solicitors to give a witness statement. And that's certainly not something that's been envisaged by the rules.
It wouldn't require the solicitors to give a statement, would it?
Well, I'm just looking at the wording. So the claimant shall...
Sorry, Karen.
The claimant shall provide a revised document production statement confirming the scope and outcome of the search, which shall list all electronic devices, etc., and confirm. So the claimant has to confirm that his legal representatives have satisfied themselves. But how on earth is he able to confirm that the solicitors have satisfied themselves unless the solicitors...
They will tell him. And if he were, if take an extreme case, I'm not suggesting it's this one, but if in the DPS he says my solicitors checked all electronic devices and so on, and the solicitors hadn't checked, then they would see that on the affidavit or on the DPS and take steps accordingly.
Well, it's the wording satisfied themselves. So I think that needs to be changed in that the claimant has to confirm that his solicitors have checked 1, 2, 3, 4 device. And then I think it's the same criticism of 3.3. In particular, confirm that the claimant's legal representatives have inspected following repositories for the purpose of determining whether or not to include it in the scope of the search. I mean, Your Lordship, my submission is that really goes too far. I mean, if the claimant simply needs to confirm, I've handed over these repositories and those listed at 3.31 to 3.37. So I provided these repositories to my solicitors and my solicitors have searched these repositories, then that's something that the claimant can, of course, testify to. But beyond that, how can he then say what the legal representatives have determined in the scope of the search?
There's always scope for redrafting, but the idea is that the legal representatives carry out what I would call active supervision or the conduct of the search. And but since it's the client that has to swear an affidavit, swear a witness statement, it could, if you like, require your solicitors also to put one to serve a statement, but I wouldn't have thought you want that particularly.
Well, Your Lordship, no, and also there's no requirement for it under the regime.
The regime is not written in stone. The court is given a fair bit of discretion as to the precise terms of any order.
Your Lordship, I appreciate that, but coming back to your earlier point, I'm not sure that KBH would want to give a witness statement.
That's what I expected. So let's put that to one side. It seems to me that the way it's drafted as getting the client to confirm that the solicitors have satisfied themselves, which he'll obviously do so on the basis of what the solicitors tell him.
Yeah. So the client to confirm in his document production statement that he has given these repositories to his solicitors and the solicitors have conducted a search against them. And I go back to my point against key terms for the issues of proportionality.
Well, let's stick to the solicitors for a moment. We could have, take 3.1 as an example. We could say and confirm that the claimant's legal representatives have told him that they are satisfied. And then that all he's doing is confirming what he's been told by the solicitors. And if the solicitors say that's not what we told you, then they can take it up with him in due course. Mr. Trotter, that sort of language would work just as well, wouldn't it?
Yes, my lord, and my lord's point is exactly right. If the claimant puts in a false DPS, then KBH will not, by their professional duties, be allowed. Be able to allow that to happen. So
if one make that a change to a like effect, whenever the document production statement is meant to say that the claimant's legal representatives have done things or satisfied themselves, if we can add in there or wording to the effect that they have said that they have done these, they have told me that they have done these things, I think that covers the point, and it'll occur several times through this order.
Yes, my lord, I don't see any difficulty with that.
Can I leave it between you two to work that out?
Oh, I would hope that much we can do.
I'd have thought you could. And what about this search terms and so on that Mrs. Ahmed is?
Well, my lord, I would hope that we won't have to involve your lordship in that granular detail. Of course, we will engage with the claimant. We have already sent them a letter 5 or 6 days ago with some suggestions, but in a sense, the proportionality of searching a particular repository depends on the repository in the way that I've described. So we don't rule out that there might be a repository that has sufficiently few documents that it justifies reviewing all of them within a particular date range. or that there's a particular issue that doesn't lend itself particularly to keywords. But each of those issues really needs to be sorted out on a case-by-case basis. And my learned friend solicitors can tell us how many documents are returned from a particular search and so on, and the parties can engage constructively in order to ensure that the exercise is proportionate in the usual way. But that's not something for today.
Can one build that into terms of section 2 of the order?
Well, my lord, it's already built in the sense that there's a provision for a reasonable search, which is the requirement of the rules. And so
it's reasonable and proportionate, isn't it?
Well, I'm not going to resist that. I think reasonable probably incorporates proportionate. I'm content for that. I mean, it goes without saying.
Reasonable and proportionate, wherever reasonable appears, and proportionate should go with it.
Yes, I am. But I need to make clear
that then builds in the idea there may be some correspondence about terms and all that to relieve the width of the inquiry.
I suspect in this case there will be correspondence, my lord. Yes.
Yeah.
Your Lordship, and just on, I beg your pardon, just on that point then, if we could look at 3.2.
Yeah.
Repository of electronic documents state whether or not it has been searched, fine. But this 3.2.2, search was conducted by the claimant's legal representatives. Instead of 2, so delete 2 to say individually reviewed, because that would be a disproportionate exercise, Your Lordship. And I hear what Mr. Trotter says. Notwithstanding that, again, I say the point that this is a hugely time-consuming exercise, and so I would invite.
Hang on, Ms. Ahmed. That's not saying that they should be individually reviewed. It's simply saying that they must say whether they have been.
Your Lordship, I don't want to get into an argument wherein then it's said that they weren't individually reviewed. And so what I would much prefer for it to be enshrined in this order to say whether the documents were, I beg your pardon, that all documents were reviewed against keywords or date ranges and what those date ranges and keywords were. So even...
Okay, Karen.
And so there's no question that if there is any search to be conducted, it would be against search words and date ranges.
The question in 3.2.2, they've only got to state, your client only has to state whether all documents were individually reviewed. The answer may be no. And if it's no, he may want to volunteer the reasons for it. And the reason may be that there's been correspondence about keywords and search terms and all that, or it may be some other reason. But I don't quite see what the problem is.
It would be helpful, Your Lordship, whilst Mr. Trotter is here, that we could agree that the searches do take place by reference to date ranges. I mean, the point is this: is Mr. Trotter and his team expecting the claimant solicitors to review each and every document? I mean, I hear what he says about whether it depends on what's on those documents, but equally, rather than go through a whole round of correspondence, it would be helpful to then enshrine or to agree that the parties will agree keywords and date ranges.
Well, I think it's been clear that the words reasonable and proportionate involve you going back, one of you going to the other side saying, I can't do this because we need some search terms, or arguments about those terms, those matters. I'm not going to, it's impossible to prescribe every step that everyone has to take.
Well, can I pick up one point while we're here?
Yes.
In 3.2.3, my lord inserted the words "and why" at the end. In order to explain. It may be that the same words should really go into the end of 3.2.2 as well, because of what just fell from your lordship, that they may wish to volunteer why it's been done in that particular way, because otherwise we'll just have correspondence about it anyway.
Yeah, so at the end of sub 3.2.2 brackets 2, close brackets, before the and why.
I mean, really, it's in respect of 2 and 3, isn't it? because 2 and 3 are really well, 3. 2
Yeah,
is yes. So perhaps
and why may cover the whole of 3.2.2.
yes. Perhaps it should be something like
not,
yes, and in each case why, or something to that effect.
something like that. And in each case why.
Yes, my lord. In both 3.2.2.
It doesn't quite cover 3.2.21, but
yes, well, yes, quite, because the assumption is that
whether the search is conducted by the claimant's legal representatives, but it is going to be conducted by the legal representatives, isn't it?
yes, I mean, in a sense, 1 is just to confirm compliance with what your lordship has ordered.
Should we get rid of 1 and just say if so, then 2 becomes 1, whether, and 3 becomes 2.
I'm just anxious to make sure that somewhere there's a requirement to confirm compliance with what your lordship has ordered to be done. And I think that may be the place for it to go.
Isn't it already there in 3.1?
Well, 3.1 is about identifying repositories of documents. 3.2.2 is about reviewing the contents of those repositories. So it's really 3.2.2, which is concerned with the review of the documents in a particular email account, for example.
But 3.2.3 basically covers the same point the other way around, doesn't it?
Well, 3.2.3 is in a case where there's no search of a particular repository. 3.2.2 is a case where there is a search. So they're alternatives. So that's why we've inserted that there.
What are you suggesting then?
So perhaps the end of 3.2.2 could just say, and in the case of 2 and 3, why? Because those are the points that call for an explanation.
Why?
But the other way of doing it, of course, would just be to say, and why at the end of each of them. So whether all documents were individually reviewed and only a subset of them, and why. And 3, if it's...
That's easier, that's tighter.
Yes, agreed.
So, and why at the end of...
Yes.
Yeah.
Yes, thank you, Marlon, yes. And then the same would apply in 3.2.3. One would have and why at the end of each of sub 1 and sub 2. So we'll have, it's not likely to contain relevant documents. And why? Yeah. For instance, the answer might be, well, I didn't have this hard drive at the time, and it's been mainly in use by my sister until last week, and so therefore it's not likely to contain relevant documents.
Yeah. Okay.
That's the sort of explanation one might have.
So and why for 1 and 2 or 3.2.3? Yeah. Okay.
Yes.
3.3 would begin with the same point about the claimant's legal representatives have said that they have.
Yes.
Have told me or have said.
Yes. The wording I had in the previous one, have told him that they have, if that is convenient.
Yeah. Similar wording throughout, whenever that appears.
Yes, no, we can do that.
3.4 goes.
Yes.
And the rest, I think, is uncontentious. Is there anything else then?
My lord, there is the question of cost.
You both want to talk about cost, don't you? We've gone past our 4-hour slot.
Yes, my lord, I don't think I need to say very much about this. I mean, the order's been made in the terms that we sought. Despite what my learned friend has said at times in submissions, it was vigorously opposed. There was an exchange in relation to the KAS documents that I don't need to go back to. And indeed, even where some of the requests were apparently agreed and ought to have been uncontroversial, there was then an attempt to row back from them in submissions in relation to the Marwar documents, for example. And so that we've been successful in obtaining the relief that we sought. A significant amount of costs has been incurred as a result. My Lord, I also have something to say about the way in which KBH have driven up the costs of this application. If your Lordship would be interested in that. My concern is that really things, the way things have been managed have really driven up the costs, and an award of costs, I hope, might make the parties conduct themselves in a slightly more cooperative manner in future. My Lord will remember that the application was initially filed on the 6th of January. There was a defect in the online system, and we nevertheless sought directions. The response we received from KBS was to resist any directions being given on the basis that the application had not been technically filed. Then again, before your Lordship, my learned friend's position was that you shouldn't give any directions, and your Lordship gave directions over those objections. Your Lordship then received a composite draft order with those directions in it, but KBH resisted those directions again in that composite draft order, and your Lordship gave the directions. And my Lord, these sorts of developments have made. Yes, thank you. I don't think I need to.
You're asking for are you asking for your costs and for them to be assessed now, summarily assessed?
Yes, my Lord. There's a schedule in the supplemental
296,000.
Where are we?
Yes, it's the wrong side.
We're looking at the defendant's statement of costs.
What page is that of this?
The total is on page 9 of the supplemental bundle. The statement of costs is the first document in that bundle. I'm so sorry. I'm not sure if I've. No, that is correct. I've mislabeled it. So the statement of costs is the first document, so it starts at page 2, and the total is on page 4. It's 348,000, and that's in AED, local currency. So I don't know if it would assist your Lordship to translate that into perhaps more familiar.
I can mentally translate it.
Your Lordship, can I address you on the issue of costs and the principle of costs?
Yes. I haven't finished.
I'm grateful.
Mr. Trotter, but it's something like 4.5 to the pound.
My Lord, my quick Google suggests that figure is around £76,000, which is a perfectly reasonable cost for an application of this kind that has involved unpicking some very jigsaw-like evidence in order to work out what was really going on, and some fairly substantial arguments of principle.
Let me hear Ms. Ahmed.
Your Lordship, you've heard my submission about this. We say that the defendants shouldn't be awarded their costs because this application was completely unnecessary. If you look at the timing of it was that we received a letter on the 19th of December with the request. It was one paragraph, you'll recall, 3 lines, the request for the Katrina documents. We then received a 13-page letter on the 20th of December detailing, and it was in 2 parts. Part A was about the scope, and Part B was a request for documents. That was responded to on the 31st of January, Your Lordship, and Part A had been dealt with. It was said that Part B, and that is the requests to produce, were being addressed and were being dealt with. And Your Lordship, even before KBH could then address those, or the claimant could address those, my learned friend then issued an application on the 6th of January. And that is on the basis that the objections, rather, that was because of the request to produce, that the defendants had been sat on since the 27th of October when the claimant objected. On the 15th of November, the claimant provided his disclosure, and it was only on the 20th of December that we say that the defendants first raised these objections. And in terms of the timing of it, the claimant has tried to deal with, engaged with, and grappled with the requests that my learned friend says his solicitors have made. And without even allowing an opportunity to the claimant to deal with the additional production order requests, Malone and Friends team issued the application on the 6th of January. Now, since then, Your Lordship, and I can take you through the correspondence, but since then, the claimant has been engaging with the defendants, has been dealing with it. The claimant was travelling over the Christmas period. His legal representatives were dealing with their own application for production, in which my Lordship gave an order as well. And so, Your Lordship, I invite you to take the same approach that you did to the claimant's application, and that is to make no order as to costs, because the claimant has been engaging with the defendants. The defendant's application was late in the context of the objections to the RTP. It was premature in the context of when they first wrote to the claimant and when the claimant had said that he was dealing with the responses, or rather the requests. And therefore, in that context, Your Lordship, we say that more or less everything in the order had been agreed. There was cooperation. It wasn't necessary. This application wasn't necessary. It was unwarranted. For instance, the updated production statement, Your Lordship, the client, or rather the claimant, had said that he was going to provide one, even in relation to the solicitor's involvement, the active supervision. The claimant had offered that he would provide the devices to his solicitors to undertake and supervise the disclosure, and therefore in that context we say that there should be no order as to costs on principle.
Do you say anything about, if I was to make an order at all, do you say anything about the schedule of costs, the defendant's schedule of costs? And it's not very different from yours. It's 50,000 dirhams different, I think. Yours is 296.
Well, Your Lordship, first of all, the point being is that if Your Lordship was minded to make an order, then it should be assessed down for the reasons that I've given, in that the defendants could have waited for the claimant to engage in the way that the claimant has.
That point I have, and I'm
grateful.
In my mind, I'm just talking about and it's seldom productive to go through line by line of the figures, but I just wonder if you had some overarching point on figures.
Well, Your Lordship, there's work done on documents that Mr. Swangard put in a statement, the third witness statement. There was no order for that witness statement, nor was there any direction, and therefore, Your Lordship, that the work done on that ought not to be allowed.
I thought you had to have a witness statement for any application for disclosure.
Well, Your Lordship, they'd provided an application and they put in a second witness statement, which there was no order for.
Right. Okay. Where does he appear in the list of work done? I don't see Mr. Swangard at all.
He's the client. He's the in-house counsel, Your Lordship, of
the
defendant.
So his time has not been claimed for.
Well, Your Lordship, there was work done on his witness statement, the third witness statement, where there was no order for that to be provided.
No, I'm just wondering where the work done on his third witness statement comes in the schedule. I'm trying to
say work done on documents.
I see. But it was quite a short statement, if I remember rightly. Well,
Your Lordship, I don't have any other points to make.
Yeah. Well, I think in this case the application was necessary because it revealed a different approach to disclosure from that which I expected on the part of the claimant, in the sense that leaving disclosure on a loose supervision basis, if I can put it that way, as opposed to the sort of active supervision or carrying out the exercise themselves, which I would have expected and which I've ordered. So that was a serious dispute, and a lot of the other disputes really followed from that. What I'm going to do is award the defendant their costs, but I will reduce it because I think there is some force in the complaints about timing and so on, which has been unfortunate in this case that things have been sort of crammed together at quite short notice. And I would be inclined, what I'm going to do is knock a third off the total claimed. So instead of 348,000, I will make it, can anyone do some maths for me? What's a third of 348,000?
Afraid my own maths is not that good, but I'm sure we can work it out. That may be the end of the matter, my lord. That there would have been one point I would have wished to make in reply, very short, but I understand if your lordship does not want to hear it.
Well, if you feel that I haven't given you the opportunity to say something important, that I perhaps ought to have done, but I haven't. Okay, tell me what it is.
My lord, it's just about that timing point. Can I just show my lord page 1293 of the bundle?
1293, and then that's the only page you're going to show me.
That's the only page. There's one paragraph.
Yeah.
My lord, the timing point is this. In paragraph 1,
yeah,
this letter responds only to part A.
Yeah.
Part B, which contains the document production requests, is currently being addressed by our client. Now, the reason why we couldn't wait to bring the application was because it would be useless for the production request to be addressed by the client, because it would just have to all be done again.
Yeah.
And so that's why we brought the application when we did, and we didn't wait for some response off in the future, we weren't told when, and some further production that was just going to be done by the client. And that would have just wasted more time, set the timetable back further, resulted in more wasted costs on my learned friend's side, and precipitated further disputes. So that's the reason why the application was brought when it was, because when the revelation came to light, we thought it was necessary to make the application promptly so that the matter could be set right at the first opportunity.
Your Lordship, may I come back to that?
Yeah.
Your Lordship, there has been an offer for where the claimant has said that he is happy to hand over his devices to his solicitors. And had the defendant's team come back and said, that's the reason, and that's what, and for that reason, we're going to make an application, no doubt that offer would have come sooner. The problem was the claimant was travelling, it was the Christmas period. And again, I make the point that this application was capable of resolution by the parties because there has been cooperation.
Okay. I'm sticking to the view I formed earlier, I'm afraid. I'm going to award the defendants the costs of this application to be assessed in the sum of 232,000 dirhams, which I think is 2/3 of. If anyone thinks I've got the maths wrong, tell me, but that's what it's intended to be, 232,000 dirham.
That's what I got, Your Lordship, 232. May I ask for a longer time period to pay, Your Lordship?
It's normally 14 days, is it?
It is normally 14 days.
How
And that's
much
for
are you asking
28
for?
days.
Any problem with that, Mr. Trotter? In the scheme of things?
Well, my lord, the usual period is 14 days. If my lord friend wants an extension, I have no opposition to her seeking that, but some reasons need to be given for it.
She is seeking it. Any particular reason, Ms. Ahmed?
Your Lordship, the claimant is an individual. I think it would be more, it would be of some utility to him.
Well, I think I'm inclined to allow. I know, Mr. Trotter, you haven't had an opportunity of coming back on that. Do you want to come back on it?
Well, my lord, everyone would like more time to pay.
More time. I know.
Your lordship has not been given any evidence or any reason why more time is necessary.
I think with an individual, one tends to be slightly more lenient about time limits for payment.
I don't think I can say any more than that, my lord.
Well, I'll allow 28 days, and the figure of 232,000 dirham. And can I assume you can get me an order without any quarrels?
I should certainly hope so. The edits to this one have been very minor, so I hope that we'll be able to get it across the line between us.
The only other point, sorry, I should have said that. I've just noticed at the beginning of 3 of the document production statement 3, it says within 7 days of the date of the order. surely that's going to take longer than 7 days, isn't it?
It is, Your Lordship. I think it's going to be impossible to meet that deadline. Your Lordship, may I just take
can we say
instructions?
14 on the basis that then maybe discussion between you and maybe longer or quicker?
Your Lordship, may I just take instructions? Just if you could just
Yes,
indulge me for 1 minute, please.
Yeah.
My Lord, perhaps I can just explain the
Actually,
order.
better wait for Miss Ahmed to be here listening to you.
Yes, of course.
Wait a moment.
Yes.
Your Lordship, the concern here is that Mr. Kahlon has given evidence that he resides in at least 3 jurisdictions that we know of: Dubai, India, and Canada, and therefore it's not clear where some repositories may be. I appreciate that doesn't apply to sort of iCloud accounts and so forth, but for instance, personal laptop, one would assume that that's with him. The hard drive, I think Mr. Kahlon has said that he will provide that to us, although there needs to be a determination of how long that might take, and then of course the work to be carried out. And so we would suggest 28 days from the date of the order. I'm assuming Mr. Trotter is going to take umbrage with that, but that's what we'd invite my Lordship to make.
Okay, Mr. Trotter. Umbrage or not?
I think there will be some umbrage with that, my Lord, because I'm bringing up the calendar. 28 days takes us to the 21st of February, which is only, that's only a matter of weeks before trial.
Yeah.
I mean,
what about 14 days? And 7 seems to, given the scope of the document production statement and the productions that need to have taken place, 7 days seems quite tight.
Yes, my Lord. I mean, the intention of this order originally, in paragraph 3, there's a requirement to just do this straight away so we can see what's been done. And then in paragraph 4 down below, to do it again once the document production's been done. But if the document production is going to be done in 14 days, then I accept, and we accepted in our skeleton, that it may be that could be, it may be a waste of time to do it twice. So if it can be done within 14 days, then we could have 14 days in paragraph 3, and then we wouldn't need paragraph 4.
Your Lordship, all I can say is that KBH will endeavour to do it within 14 days and we'd request that there is some buffer to that. And it may be that KBH can provide document production in tranches in the same way that the defendant has provided their documents. And so, of course, 14 days, we have no objection to that, with the proviso that if it does take longer in relation to certain, let's say, repositories, then my friend's legal team will take that into consideration and there can be some cooperation in that respect.
Well, you can always apply. I hope not. That won't be necessary. But you can always apply for an extension if matters prove impossible, and an application based on reasonable grounds will, one would hope, be accepted by the other side and make some sort of consent order. But let's say 14 days and delete paragraph 4 of that part of the order. And then, as I say, if problems arise, it can be dealt with by negotiation or application to the court. Yeah.
Thank you, my Lord. I mean, I want to put down a marker that this is a concern about the trial. If the disclosure is going to push on a great deal longer than that, then it is really going to start causing some serious problems.
Right. Marker noted. Thank you both very much for your help. And can I assume that you'll send the case the registry a draft of an agreed draft of an order made that as we've gone through?
We'll do that. Thank you, my lord.
Thank you very much. Thank you.
you.